Yeah.
It was surprise. Yeah, I was waiting for that kind of the 1-2 punch, and it didn't happen.
Yeah, it's possible that he's planted the seed and he's going to water it later, coming back to that with other witnesses or coming back to that in closing argument. That's a possible strategy. Personally, I think if you're going to plant a seed, it can't be hidden.
You want to bloom it.
Right.
You want it to bloom. You want it to you want it to grow and become a flower.
Because otherwise, what you risk is the jury, says, I don't remember that. It becomes some obscure thing someone said days and days ago that you want me as the jury to remember. I don't know. It's possible. I think that would be a good argument.
And the other thing you risk letting Trump into the room is all of Trump's legal baggage walking into the room too, which could affect Paxton. I mean, the indictments related to anything on January 6th, Paxton was there too, speaking. That's a little bit risky because Paxton has worked hard to tie himself very closely to Trump. Has filed suits challenging the 2020 election in 5 other states besides Texas. I mean, he is deeply linked to Trump, and Trump is having a few issues these days.
As his defense, I wouldn't be so worried about that because public opinion of Trump is one thing. What matters is the jury, right? And if I'm the defense,
that's true.
I don't care about the Democrats. I know they're against me. I just
that is their
assume,
core audience.
I'm trying this to hardcore Republicans that are very MAGA, very Trump, and so frankly, I think I don't object to, and I would do the same thing if I was them, trying to tie Paxton to Trump, legal trouble, notwithstanding.
And if you had been doing that cross, you'd have been doing the yes no. You'd be trying
to
lock
him in.
They
also then tied that witness to Trump.
Right. That's what I would not have let. I would have made this. Paxton is a Trump guy, and I wouldn't even give them a chance to side
because
with
they're
Trump.
traitors and
because they're traitors and rhinos.
They were trying to have
as the defense, you'd want to set this narrative that this was a mutiny. This was a bunch of unelected bureaucrats trying to, they didn't like what their boss was doing, so therefore they decided they were going to do a coup, basically.
Yeah, because ultimately you got to remember the Senate is full of people who served in the Senate with Paxton. He is one of them, and the Senate is.
Some of them served in the House with Paxton.
Right, and they are. This is a more conservative body in Texas than the House, and so, I would definitely be tying him to Trump. But I think that was just sloppy. Maybe he felt it in the moment. Oh gosh, I can't believe I let him do that. I gave the witness the opening because once the prosecution gets to tie their witnesses to we're good Trump God-fearing Americans, that's a bad look for
because it's hard to say he's a rhino when that's what's happening. One of the things, comments I saw, somebody was asking, one of the questions somebody asked, did the prosecutors out-strategize the defense by the order of the witnesses? And I think what they meant by that question was your first 2 witnesses, Jeff Mateer, and Ryan Bangert, neither of them participate in the lawsuit. And then Bangert also, furthermore, can say, I was stripped of my job duties, I resigned, I feel like I signed my death warrant. Thoughts on that?
Yeah, absolutely. I think that's really smart strategy. Start, one, you want to start strong, and I think they've done that with good, compelling witnesses. But also, you take away the ability of the defense to say, these people are suing, these people are, they have a vendetta, they stand to gain from this.
Right, they're going to get some money. They're getting that part of that.
They're getting that part of the $3 million that they wanted the taxpayers to pay.
Yeah, and then with Bangert, you get somebody who, again, we talk about bona fide conservative credentials. He goes to the Alliance Defending Freedom. It's not like he jumped ship and now he's a Democrat.
Well, Mateer went to the Liberty Legal Institute. Right. Again, we are not.
These are very, very.
They went from a conservative place to. You could make the argument these are much more deeply conservative organizations that they went to, both of them.
And again, kind of like the right of the right,
And I think even Mateer described himself that way.
Yeah, he's a very, very, very conservative guy, and so is Bangert. These are very. It's hard to see how you can even make the claim.
They put up their strongest.
Right.
Their one. There's no way they have no no weak spots really for them to go after.
That's right.
And they've set the tone now for the other witnesses that do come up.
One thing I want to bring up before we go eat lunch is that we have something we didn't get to talk about right before, which we were the issue of the offered for the matter. Can you kind of walk us through that, because that was the whole thing that was kind of arising there with.
Yeah. So hearsay is one of those things that regular folks who don't practice law have an idea of what hearsay means, but hearsay in a courtroom is a very particular thing. And so hearsay is an out-of-court statement that is offered for the truth of the matter asserted, which is frankly, a very lawyerly way of saying, this is a statement, and I want the jury to hear it because I want the jury to believe the statement. Okay, that's hearsay. Not all out-of-court statements are hearsay. Me saying Tanya told me yesterday doesn't necessarily make it hearsay, unless my argument is, and I want you to believe what Tanya said.
Right.
When
and you should believe what I said.
Okay, well that's hearsay.
There we go.
So, objection sustained. So the when we heard Rusty Hardin say, well, wait a minute, I'm not offering it for the truth of the matter asserted. Frankly, I had been sitting here saying, I don't know why they're not making that argument, because a lot of the statements weren't, and I want you to believe what these people were saying. It's for the effect on the listener. That's one of the exceptions to hearsay. It's for to show the mind, the state of mind of the person making the statement.
Right.
I could be.
And that was a specific question that was asked
That's
at
right.
one point. What was the state of mind?
Right. And so Dan Patrick, I think, correctly ruled there, regardless of how you see this case. Talking about just purely the law. If I'm saying I want to introduce a statement that Joe told me it rained yesterday, right? That doesn't necessarily make it hearsay. Now, if I'm trying to say, and therefore you should believe it rained yesterday, that's hearsay. But if I'm trying to show that Joe is clearly crazy, because we all know it didn't rain yesterday, or that Joe has a, whatever, then that's not hearsay. And so that's what was going on there, and I understand that. That's something that even, frankly, a lot of lawyers struggle with that aren't in the courtroom practicing trial law.
So after lunch, you think they cut bait with this guy, or do they keep going?
I would.
Well, he says he's going to keep going, but you saw that Busby's in the room. He's there now.
Yeah.
He wasn't earlier.
But they can't switch horses, right?
They can't switch horses, I don't think. I think
assuming
you're right.
the standard rules of trial.
Well, that's true. We're not
dealing.
We're not in Kansas anymore. Who knows what they're going to allow? Although I think, again, Judge Lana Myers, who's advising Dan Patrick, I would be shocked if she advised him that was a good idea. But yeah, if I was the defense, I would say, look, we've made. We planted the seed, here. We made an argument there. We're not really landing any good body blows here. Let's just get out.
Losses.
Right, yeah. Because the concern is jurors, whether they're senators or everyday citizens, are regular people. If you bore them, if they think, why are we talking about this nonsense, they're going to stop listening.
Right.
And you are teaching them that I'm going to go on about nothing, and you can just disregard. And then the risk is you land a really important point later and no one's listening.
Right.
And so that's why
they've all zoned out.
Yeah. Unless, maybe he has a real zinger left and he's going to come out and hit his home run, and then, but unless he has that, I would, if I was Busby, I'd tell him.
I don't see that happening with this witness.
Bangert seems like the kind of guy who is very methodical, very careful. It's kind of hard for me to believe you're going to have a zinger with this guy.
Yeah. He has demonstrated over and over that he's not going to let you back him into a corner, that he's going to be very careful with his answers. Unless you just have something that's unimpeachable, point to make, I don't think you're going to get it. Yeah.
No, absolutely. Okay, folks, we're going to take a lunch break. We will try, depending on how quickly we can eat, to come back at 1 o'clock or maybe 1:05. And try to get started a little bit before they get back in session. But we'll be back, and please keep watching.
A little bit on scheduling. We will go 6:30 to 7 this evening, depending on where the right break is. Tomorrow, I had planned to adjourn at 5, but a number of members said traffic, if you leave at 6, you don't gain any more traffic leaving an hour earlier, so we'll go to 6 tomorrow. And I've had a request to extend lunch to 60 minutes for the court, so people have more time, so we'll start that tomorrow. So today, 6:30 to 7, tomorrow to about 6, and then an extra 20 minutes for lunch. So we are ready to resume.
Ready.
Counselor, could you come forward for one moment? Bailiff will bring in the witness. You may begin.
I'd like to approach the court and opposing counsel with just a piece of law, Your Honor. Statute.
Can I have an exhibit number again, please?
It's not an exhibit. I don't intend to offer it as an exhibit. It's just a statute. I'd be happy to if you'd like me to.
I'm not sure I'm going to object, but can I understand what the purpose, I mean, you're going to ask the witness about it, or?
I do intend to ask the witness about the law on non-judicial foreclosures.
Are you perhaps having it here for him to refer to in case he doesn't know it?
I have a copy in case he's going
Counselor, if
to
you can address the court.
Sure.
Both of you can address the court.
I'd be yes, Rusty, and I'd be happy to offer it as AG 1005.
If it's not being introduced to evidence, I don't have any objection to what we're doing, I don't think. I just don't know what a statute, if the court has it, I don't know whether the court has it.
Okay, we do have it. I thought I heard you just say if it's not being offered as evidence, you have no objection.
That's correct, that's correct.
Okay. So?
At this time, I don't intend to offer it into evidence. Mr. Bangert, are you
We're on the same
aware?
page?
Yeah,
Okay.
all right. So, did you just say now that you are offering it?
No, I
You're
said
not offering it.
I wasn't offering it at this time.
Thank you.
I might change my mind here in a second. We'll see.
All right, fair enough.
Mr. Bangert, you are somewhat familiar with non-judicial foreclosure law, correct?
Did you ask, am I familiar with non-judicial foreclosure law?
Yes, I asked you if you were familiar with non-judicial foreclosure law.
It's been a while.
Okay. Well, you did write a memorandum about it and issue an informal legal opinion on the matter, correct?
If you're referring to the August 1st letter, I did assist Mr. Vassar in putting that together.
Okay. And in doing so, you probably had to research the law on non-judicial foreclosure opinions, true?
Not necessarily.
Okay. You're aware of when non-judicial foreclosures take place, correct?
Based on the document that I prepared, I believe it was the first Monday or Tuesday of every month, but
Okay.
that's my recollection.
Okay. If we said it was Tuesday, would you agree with that?
I would have no reason to disagree.
Okay. Now, the fact that that occurs every single Tuesday, that singular Tuesday of every month, that's a reason that Ken Paxton could have said, Mr. Bangert, we need to get these done this weekend. True?
Yes, that could have been a reason.
Okay. And to be fair, Nate Paul is not the only person that had properties that were subject to potential foreclosures on that date, was he?
I don't know for a fact, but it seems reasonable to assume there would be other properties that would have been subject to foreclosure.
Okay. Potential homeowners, correct?
Again, I don't know of any particulars, but it's entirely possible.
So it's safe to say that it could have been someone that didn't have a job and didn't have money to pay their home loan, correct?
I have no reason to agree or disagree with that. I don't know.
Okay. After that informal guidance was issued, and to be clear, Eric, would you mind pulling up House Boards 119? That was not issued like a legal opinion was normally issued, correct?
Are you referring to?
No, I'm asking you personally.
Which
That was
document?
not issued like a formal legal opinion, correct?
It did not go through the formal process.
It was really
To the witness, excuse me, if you can just answer yes or no when you can. Okay.
It was just a news post, right?
Which document are you referring to?
I'm referring to the informal guidance regarding the non-judicial foreclosure sales that you signed instead of Ryan Vassar.
No.
It was a post on the website, right?
I believe it was made available to the public via our website.
Okay. And if we look at House Board 119, you state, we compromised by urging that, we agreed to compromise by placing a short, noteworthy post on the website, correct?
Yes, I wrote those words.
Okay. Now, after that noteworthy post was issued, we're in August of 2020, true?
We are in August of 2020, and I do think I need to correct the record on something
Just
that
a
you
yes or
asked
no
me.
question. Was it August of 2020?
We are in August.
Okay. You had no knowledge about anything to do with the renovations with regard to Ken Paxton's house at that time, did you?
The knowledge I had would have been through conversations with Mr. Mateer via Mr. Wicker.
You have no personal knowledge of that, do you?
I did not discuss that with Mr. Paxton, nor was I at his house.
You do not know who paid for the renovations to the Paxton's house?
At that time, I was unaware of who was paying for the renovations.
You don't know. You haven't seen any documents, have you?
I have seen documents that include testimony from individuals who have described...
It's a yes or no question.
I have seen
Have you seen documents that specifically show and prove who paid for those? Have you seen receipts?
I have seen documents strongly suggestive of who paid for that. Okay.
When did you first send your application for the Alliance Defending Freedom?
It would have been sometime in October.
Okay. Was it prior to leaving the Attorney General's office?
Yes, I was in conversation with ADF prior to leaving the Attorney General's office.
Okay. So when you said earlier that what you did with regard to reporting Ken to the FBI, going to the FBI being a death warrant for you, it did not affect your ability to get another job, did it?
It ended my ability to be employed by the Attorney General's office.
Well, no, because you resigned. You didn't get terminated, true?
I was constructively terminated.
Okay. You submitted a letter of resignation, did you not?
I did.
And then you went to work for a company or a firm that you had already applied for, true?
I did.
All right. In the end of the day, you would have to agree that Mr. Paxton makes the final call on what opinions are issued by the Office of Attorney General, true?
I wouldn't put it quite that way.
Well, he has to sign the document, doesn't he?
Mr. Paxton has authority to make the final signature on the document.
So in the context of a senator perhaps, if there's a piece of legislation that they don't like, or let me rephrase that, if there's a piece of legislation that one of their staff members does not like, and they want it to go through, the senator overrules his staff member, true?
I do not know how the senators make their decisions. I can only assume that senators, much like statewide elected officials, have ultimate authority in their offices.
Have you had any conversations with any statewide officials or legislatures regarding this case?
Nothing specific.
Nothing specific. Is there any record of that, of what you actually said?
No.
So it's kind of like your conversations with Mr. Hardin and the House Board of Managers?
No.
May I approach you, Your Honor? At this time, Judge, I would offer Attorney General's Exhibit 1004.
No objection. It will be admitted into evidence.
May I approach the witness, Judge?
Yes, you may.
Mr. Bangert, I've highlighted in orange on this document. I'm going to hand it to you. I'm going to ask you to read it, okay? The highlighted portion, okay? I want you to read it aloud, Mr. Bangert.
The highlighted portion.
One moment. Does Eric have it?
Eric does not have it, Judge. This is more of a rebuttal exhibit, if you will. So, Mr. Bangert, if you could read it aloud so that our jurors could hear the highlighted portion.
Pardon me, Your Honor. May I approach him and ask him to highlight the portion that he's highlighted for the witness so I'll know what he's talking about? I just want to highlight on my copy. Thank you. Thank you.
I'm going to ask you to read the highlighted portion now. Aloud, Mr. Bangert.
The highlighted portion states, accordingly, my administration, to the extent reasonably necessary to prevent the further spread of COVID-19, will take all lawful measures to prevent residential evictions and foreclosures resulting from financial hardship caused by COVID-19.
That is an executive order issued by the Trump administration. Mr. Bangert, were you aware of this executive order when you filed or sent Mr. Vassar that email on September 30th of 2020?
Look at the date of the order. It's August 8th. I don't recall if I was aware of this order, but it was irrelevant.
It was irrelevant?
Yes.
Okay. It was a week after you just issued an opinion with regard to foreclosure sales, was it not?
It was 1 week after the August 1st opinion.
Okay. But it's your opinion that it's not relevant to your summary of what happened on that foreclosure opinion you drafted?
Completely irrelevant.
Okay. I'll take that back from you. May I have a brief moment, Judge?
Point of inquiry, please, Your Honor. I'm looking at the record as it was. Maybe counsel wants to have an opportunity to correct it. I think he referred to the order in a question. That is an executive order issued by the Trump administration, Mr. Bangert. I suspect he meant to say the Abbott administration, but I just want to make sure the record is correct. I don't know which he meant.
No, it's a federal order. I meant the Trump administration.
Pardon me?
It's a federal order. I meant the Trump administration.
Thank you. Okay.
I want to talk to you more about your representation by Johnny Sutton, Mr. Bangert. Was it after you ended your employment at the Office of Attorney General that you hired Mr. Sutton?
I began working with him prior.
You began working for him prior?
I began working with Mr. Sutton prior to ending my employment, yes.
Okay. You searched for Mr. Sutton on September 22nd of 2020, did you not?
He was recommended to me.
Okay.
I can't recall searching for him on September 22nd.
Okay. This time, Your Honor, I would offer Attorney General Exhibit 312.
Any objection?
No objection.
It is admitted into evidence.
Okay. Mr. Bangert, this is a download of your computer, and I'm going to approach you with it. I'm going to have you look at it and refresh your recollection. I didn't realize Eric had. Eric, you got it published, don't you? Okay, thank you. We see here on September 22nd of 2020 that you actually searched Johnny Sutton's law firm.
That's what the document represents, that I searched for the ashcroftlawfirm.com.
And that is where Johnny Sutton is employed, true?
He's one of the named partners there.
Okay. That is 8 days before you decide that you're going to go to the FBI and report Ken Paxton.
We went to the FBI 8 days later. Yes, that's correct.
So you were searching for an attorney before you even knew that Brandon Kamick was issuing subpoenas at those banks.
Oh, no, I don't believe this had anything to do with looking for Mr. Sutton to retain him.
Oh, it's just a coincidence? Yes or no?
It probably is, yes. There's no reason. We were not searching for a counsel prior to that. I was not.
I'm going to ask you a question that Mr. Busby has stated earlier. Have you ever heard the term, there's no coincidences in the city of Austin?
I've never heard that term before. And there are plenty of coincidences.
It was a yes or no question, Mr. Bangert. You said you'd never heard of it.
Never heard of it.
So September 30th, you guys go to the FBI, true?
We did.
All right. Now, that is before you become aware of a second referral made to the Travis County District Attorney's Office, true?
Trying to recall when we became aware of that second referral. It may have been, I just don't recall precisely the order of events, but I believe it was.
I mean, you seem to have a great recollection of the order of events when Mr. Harden had you on direct examination. Are you saying that you're forgetting now?
No, I'm telling you that I'm trying to recall specifically when I learned that fact, but I did learn that there was a second referral.
Okay. And it was after you went to the FBI?
That is entirely possible, yes.
Okay. And then the next day, that is when you guys decide to reach out to Ken Paxton, after you've already outed him to the feds, right?
We reached out to him the next day.
Okay, that's what I said. So that's a yes, right?
We did reach out to him the next day.
You were pretty active.
The witness, but once again, witness, when you can answer yes or no, if you can, answer yes or no.
I cannot answer yes or no to that question. I'm answering what I can.
Okay. You were pretty active on October 1st.
I was active on October 1st, yes.
Okay. You guys, when I say you guys, I mean the executive level administration. You had a group chat going, did you not?
We did.
And you participated in that group chat, right?
Yes.
We heard you talking to Mr. Harden about some of the text messages in that group chat, right?
Yes.
And specifically, they were talking about a draft that was circulating between you and the other executive level attorney generals, right?
Yes.
Eric, would you mind pulling up House Board 225? And in that message, well, it's safe to say that the first draft that you all created did not go to the FBI, right?
I don't know. This letter that's
Right.
being referred to here?
It
No.
was revised and edited to an extent.
The document, I don't recall if it ever went to the FBI. We were working on an internal document
Okay.
to memorialize our complaints.
Right. And the first version of that complaint, well, from what we look at in House 225, Jeff Mestier says, from Maxwell, read the letter, not sufficient. A request letter must allege specific allegations that are in violation of state law to include documentation of criminal act. The only thing you have is what happened today, and that is documented. Is that true?
You added the word "and."
Okay.
But apart from that, you read it
Excuse me?
correctly.
But that's what the text says, right?
That is what the text says.
And
with that addition.
presumably that's regarding the initial draft that you guys created to memorialize your complaint to the FBI, right?
I don't recall specifically that that's what this was.
Are you forgetting all of a sudden? Because you had a crystal clear recollection when Mr. Hardin had you on direct examination, Mr. Bangert. Do you not remember this? You're here to testify in the court of impeachment. Do you not remember the day that you went behind Ken Paxton back to the FBI? Do you not remember that?
Sir, we did not go behind the Attorney General's back.
Did you tell him you were going to the FBI? Yes or no?
Sir, we did not go behind the...
Mr. Bangert, I'm asking you yes or no questions. Did you tell Ken Paxton you were going to the FBI? Yes or no?
I cannot answer that question with a yes or no.
Witness, you'll answer the question.
Yes or no, Mr. Bangert?
Provided him with ample opportunity.
That's not what I asked you. Did you tell Ken Paxton you were going to the FBI? Yes or no?
We gave him ample opportunity.
That's not what I asked. Objection non-responsive, Your Honor. I'd ask that he answer the question before him.
Witness is ordered to answer the question, yes or no.
Mr. Bangert, it's a very simple question. Did you tell Ken Paxton that you were going to go to the FBI?
On September 30th, we did not.
It's a yes or no question, Mr. Bangert.
It's
a
not
yes or no.
a yes or no
It is a yes or no question.
Excuse me, sir. Your Honor, he said, he answered the question, but because he was talking on top of him, he didn't hear it. He said on September the 30th, we did not. And he starts interrupting him halfway before, and the court reporter probably had trouble hearing. We did not. So I just asked him to let him finish what he's saying and not talk on top of him, if for no other person than the court reporter.
You can ask the question one more time.
Mr. Bangert, it is a yes or no question, and I want a yes or no answer. Did you tell Ken Paxton that you were going to the FBI?
I did not tell Ken Paxton before I went to the FBI.
We're not done with that. Your next message after we're talking about the first draft of y'all's complaint says, okay, sounds like we need to beef up the specific allegations, does it not?
Yes, that's what I wrote.
So you actually had to go back in there and put more words and more filler into that complaint, didn't you?
No.
No? Well, the first complaint clearly wasn't sufficient if we're to go off your text messages, right?
You said the word filler. That's an inaccurate characterization
You had to
of what
amend
we
it.
were doing.
Well, let's look down there. Eric, if you could hop off of the zoom in. It says, sound like we need to beef up the specific allegations. You needed to beef them up, right? You needed to make them sound stronger. True or no?
We needed to include additional allegations to substantiate what had happened.
Okay. And so it's after that that you started talking about other things that Ken Paxton had done previously that you didn't think to include in the first version of the complaint, right?
I wouldn't put it that way.
You wouldn't put it that way. And to be clear, this is all coming to fruition because Brandon Kamick is serving subpoenas on a bank, true?
That was in part, but not entirely.
And all the while, you didn't even know that the Travis County District Attorney's Office sent a complaint directly to Mr. Kamick that did not go to the Office of Attorney General.
That would have been much more concerning if I'd known that.
So you didn't know that?
No.
Okay. Eric, would you mind pulling up Article 6? Or excuse me. Article 5. The allegation in Article 5 is that Paxton misused his official powers by violating the laws governing the appointment of prosecuting attorney pro tem. You would agree with that, right? That that's the allegation?
Yes, that is the allegation.
Mr. Bangert, Mr. Paxton, Brandon Kamick was not an attorney pro tem. True or not true?
It's difficult to classify what he was.
True or not true?
I don't personally believe he was properly ever appointed a prosecutor pro tem.
and the Travis County District Attorney's Office never recused themselves officially and formally from the complaints made by Nate Paul to their office. True or not true?
I'm not aware of any recusal.
Okay. May I approach you, Your Honor?
Yes.
I want to go back to your last answer, and I'm going to re-ask you this. Brandon Kamick wasn't just not improperly appointed as an attorney pro tem. Brandon Kamick was not appointed as an attorney pro tem at all.
Not to my knowledge.
At this time, Judge, I would offer AG Exhibit 95.
I think that's on our list of already admitted.
It is. No objection.
Okay.
It's already admitted.
Thank you, Judge. Eric, would you mind pulling up the first page to AG 95? Mr. Banger, we talked about you being heavily active on October 1st of 2020, and you agreed, right?
I was.
And one of the many actions you took that day was that you took it upon yourself to email Jeff Mateer's letter to Brandon Kamick terminating his employment, did you not?
I did not take it upon myself. I agreed with Mr. Mateer that this would be an appropriate way to handle this.
Okay, so you and Mr. Mateer were both of agreement to do that.
We were in agreement to do this.
All right, I want you to flip to the second page of that correspondence. You would agree that, and Eric, if you would do the same, you would agree that that is the letter that Jeff Mateer provided to terminate Brandon Kamick's employment, right? It's produced by the House, Mr. Bangert.
Correct. I want to make sure that the word terminate is accurate here. We were told him to cease and desist.
Third line, notice of termination effective immediately.
Yes, we do say that.
Okay.
Yes.
And just to be clear, you don't know all the work that Brandon Kamick put into that investigation, do you?
At that time, I was not aware of what he was up to.
And you were willing to just fire him without even thinking to pay him or compensate him for his time and his services as a lawyer?
We terminated him in this letter and told him to cease and desist.
Without even thinking about giving the guy a little bit of money for the time and effort he spent on this investigation? Yes or no?
I would not put it that way.
Okay. You didn't pay him, did you?
No, we did not.
All right. But the thing I really want to focus on, Mr. Banger, because you're a man that has attention to detail, right?
I do my best.
I want you to look right under that Attorney General seal at the top of that exhibit, okay? Do you recognize anything that should be there?
It's been several years since I worked with letterhead. It has the seal of the Attorney General's office there.
How about your boss's name? You see that there?
His name is not here, no.
Yeah. You went ahead and sent it without his name, didn't you?
I'm trying to recall. I think there was a version.
You're looking at the document, Mr. Banger.
Excuse me, he's trying to answer the question. Can you please let him before he jumps?
Overruled.
You're looking at the document. Is Ken Paxton's name on that document you sent to Brandon Kamick or not?
His name is not on the letterhead, no. But just for the record, I do want to point out his name does appear in the letter.
Objection, Judge, to non-responsive. I didn't ask this witness a question.
Sustained.
And I'll pass Mr. Banger.
Mr. Bangert, I want to start to try to ask you a few questions again to go back to this opinion that sometimes has been referred to as the midnight opinion. Originally, if I can, I would like to bring up, please, Stacy, Exhibit 112. Now, can you look at this and determine and help me out and tell me whether or not this is the original draft that y'all did on and presented to the Attorney General on that Saturday afternoon? You need a moment to look at it, or would it help you to have a hard copy?
A hard copy would be helpful, yes, sir.
Can we? And Stacy, do we perhaps have a hard copy for the court?
But I can tell you without looking at it that this is not the original version that we sent.
Now, let me follow up on what your observation is. What order would this draft have been?
I'm assuming this is the final draft. It would have been the very last thing that was produced.
Would you look at the first page, please? And the last page, if that helps you.
No, this is not the final draft. I can now see there's no signature on it.
Right. Would you look at the opening paragraph and see what that seems to be saying in terms of the original position you took?
Yes, this refreshes my recollection.
Pardon me?
Yes, this does refresh my recollection as to that.
And now that you look at the language in the first paragraph of Exhibit 112, what does that tell you in terms of which draft or order it was?
This was one of the early...
Now, let me tell you a problem for you to keep in mind. When you look to the left for the iPad, there you go. Perfect. There you go.
There we go.
All right.
Yes, this was one of the early drafts.
And in the first paragraph, would you look at the sentence that begins with "we conclude"? Would you highlight for me, Stacy? Read this paragraph out loud to the jury, please.
Yes. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA 28. And local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right. Now, at that time, what was the legal basis for you concluding that there wasn't a restriction and that it could be conducted?
It was GA 28, the governor's order.
All right. And what was it about GA 28, the governor's order? And I may have a copy there. I couldn't locate it on my desk. If somebody finds it, they can bring it up to me. But what was it about the governor's order, and when was that order that you concluded would allow essentially the foreclosure sales to go forward, particularly outside? Thanks. Thank you very much.
Yes, there were a number of exceptions in the governor's order to in-person gathering restrictions.
With the court's permission, I'm going to mark this as an exhibit number 621. Thank you so much. 631 or 633? 631. Thank you. I'm going to tender it to counsel, Your Honor, because I don't have an extra copy right now.
No objection, Judge.
631 shall be admitted into evidence.
Thank you, Your Honor. Do we have a copy by chance for the court to have up there?
Always nice for the court to have a copy.
This only came up during the lunch hour. I apologize.
Thanks, sir.
And one for him. Thank you very much. Now, I don't know whether or not, and I'm going to ask as we go along, whether Ms. Manella can figure out a way to balance these. First of all, if there's a way to do a split screen here, Stacy, 112 and 115, and I believe I will represent that 115 is the final order. And I believe 115 is in evidence. Now, if you could look at these two orders, is the one on the left, the draft we talked about, Exhibit 112, what your first finding was?
Yes, our first finding is summarized in the first paragraph. We conclude that a foreclosure sale. Yeah, there we go, thank you. We conclude that a foreclosure sale of residential or commercial real property constitutes a service to which no occupancy limit applies under Executive Order GA-28, and local governmental bodies therefore lack authority to restrict in-person attendance at these sales.
All right, now, I'm going to ask you if you could leave that up, please, Stacy, first. And then I want you, if you would, I want you to look over to the government's executive order on page 3.
Okay, and I don't have a copy of the order.
Do we have one more, Mark? No.
Thank you, sir.
Thank you. And I believe that 112 was just never discussed as one of those that you did not object to. I want to tender it to you again to look at. I just looked, make sure. I'm told that 112 is not in evidence, and I apologize. The headlining is not. This is the original draft they proposed to him.
No objection, Judge.
No objection, 112 will be submitted to evidence.
And I apologize for having published that before I realized it. That's my fault, not anybody else's. Now, I want to ask you, you referred in your testimony just a moment ago that in your first draft, in which you basically had a ruling that said these foreclosures, particularly outside, would be allowed. And then you said that was partly based on the governor's executive order that he had previously issued. And you talked about it as General Order 28, correct?
Yes, no occupancy limit applies.
I'm sorry?
Yes, no occupancy limit applies under GA-28.
And what role can you point us in the governor's General Order 28 to the section that you relied on in that initial opinion that said they could be open to the public, they could foreclosure proceedings could be open?
Yes. May I see the second page of Exhibit? May I see the second page of Exhibit 112?
All right. We move to second page. Thank you, Stacy.
Yes. Yes, we referenced it here. We address your question.
No, I'm sorry, Stacy. What I want to do now is go to, if you have ordered, I don't know if you have 631 loaded, do you? If you do have 631 loaded, could you go to the second page of that? And you can sacrifice the one on the right. You can take down 115 and put in the governor's general order. And by the way, the executive order, before you move, Stacy, that is dated. Can you see on there what date it is? Is it June? Can you see June 20th?
I can. It's June 26th, 2020.
All right. Now, so that executive order, did it not, existed at the time that you were drafting your opinions at the request of the Attorney General?
They did.
All right. Now, what is it on page 2 of the governor's executive order that led y'all to conclude and say in your first draft that foreclosure sales could be conducted?
Yes, if you will go to page 2 of Exhibit 112.
All right, Stacy, if you go to page 2 of the
first
general
full
order.
paragraph.
Pardon me?
The first full paragraph. We point out that Executive Order 28 has a baseline limitation that does not apply to...
I don't, I'm confused here, and it's probably my fault. Stacy, may I approach, please? As usual, Ms. Manello is more on top of it than I. You directed me, and it's my fault, you directed me to page 2 of
Exhibit 112.
112, your initial draft opinion.
The initial opinion.
And I was trying to go over to the governor's order. But let's stay with 112 first.
Okay.
So now, Stacy, let's put up 112 and the governor's order. Those are going to be the two on the screens. Go ahead. All right, tell me what it is about 112 that you think is relevant to what we're saying.
Yes, this paragraph that is highlighted,
All right,
second
move it
paragraph.
away from that microphone. You got to move it to
Yes.
you. There you go.
The paragraph calls out the executive order's baseline limitations on gatherings. It then says this limitation does not apply to any services listed by the U.S. Department of Homeland Security's Cybersecurity and Infrastructure Workforce version 3.1 or subsequent version. CISA guidance is how we referred to that. Among the services listed in version 3.1 of CISA are residential and commercial real estate services, including settlement services.
And then if we go down to, you go down to about a sentence or two down there, you say, do you not? And there is no better indication of that intent than the words that are chosen, correct?
That is correct.
All right, now let's stop there and let's go over to the second page of the general. And by the way, could you just explain to us lay people what CISA is, C-I-S-A? What does that stand for?
It's the Cybersecurity Infrastructure Workforce. CISA is I'm trying to recall exactly what that acronym stood for, but there was a guidance document issued by an agency within the federal government that called out essential services and infrastructure that should be exempt from COVID limitations.
Okay, so for us lay people, essentially, are you saying that you are going from your draft that you did to show why the governor's proclamation or executive order would have exempted it as far as you were concerned when you dropped the original draft, is that right?
That's exactly right. We were trying to demonstrate, and we did demonstrate here, that a straight application of the governor's executive order excluded these types of foreclosure sales from limitations.
All right, stay with me. I don't want to tell everybody how to build a Swiss village when we're trying to just do what time it is. But if we go to page 2 of the governor's order, where in there does it point people to the legal basis you made for your original order?
Paragraph 1A.
Stacy, can you, on the left, can you do 1A? Thank you. Can you highlight 1A for me? There you go. Mr. Donnelly wants to make sure that I let you know that we can't give you a copy of the CISA document because it's a government confidential document, okay? But having said that, would you explain in this highlighted language how this tells you...
Objection to that sidebar about the CISA document. I don't believe it's confidential.
Sustained.
Can you explain in the highlighted portion here?
Say again?
Yes, explain in a highlighted portion how that impacted your original opinion you recommended in a draft to the Attorney General.
Yes, this was part of the exemptions from occupancy limits, and the CISA guidance called out a number of essential services, infrastructure, among which, as we point out in our original draft guidance, are residential and commercial real estate services, including settlement services.
So explain to the court what that meant as far as the conclusion that you ultimately reached and recommended to the Attorney General.
Based on a plain text interpretation of the governor's order, foreclosure sales would not be subject to occupancy limitations.
If it affected any real estate?
Yes, and that was a straightforward textual interpretation.
So in your original one, did you actually base it upon an exception the governor's executive order had given to say that it should be open to the public?
Yes, it was a straightforward application of the governor's executive order.
Now, how did you get around that then when you were ordered to come up with a different answer? And if we can, Stacy, let's now take down the governor's executive order and put up Exhibit 115, please. Now, tell us what it is about what did you do that, since you had based it on a specific reading of the governor's statute, and now you're being asked to give an opposite view? How did you do that?
Could you go to page 2 of Exhibit 115?
Yes. Where do you want to be?
If you'll look at the third paragraph. We simply jump straight to the general occupancy limits.
Pardon me?
We jump right to the general occupancy limits, excluding conversation about CISA.
Direct us and Ms. Manella where to highlight that you're talking about.
The language, this general limitation, however, is subject to several exceptions.
Where you read?
One such exception is found in paragraph 5 of the order, which limits outdoor gatherings to 10 persons or fewer without approval by the mayor or the unincorporated territory. So we switched out the applicable exceptions in the order to eliminate any reference to the CISA guidance.
So what you did is you just wrote out a paragraph, did you not, of the governor's order?
We determined, based on the Attorney General's instructions to us, that we would no longer apply the exception that had been granted by the governor's order.
When you say based on his instruction, did he actually talk about that language?
No, he told us to reach a different conclusion, and that was the only way to do it.
I don't need it, but thank you. All right. Now, finally, I want to make sure, I don't know that I need to introduce this, but had you read, may I approach the witness very briefly?
Yes.
I want to approach you and show you what we have just marked as a new exhibit. House Board of Managers Exhibit 632 is a new listing. I'll tender to the court and the council with the admonition that I don't intend to read all this. So my question to you, though, without having introduced it yet, I will actually make it for ease, move to introduce it. We move to introduce House Board of Managers Exhibit 632.
Judge, I would object to this witness testifying to this document, and additionally, this document has not been produced. There's no bait stamps on this document.
No, that's certainly right. It has not been produced. We never foresaw this issue. So we've just gathered this during the lunch hour and printed it out here, and we've tendered it to him. Whatever his position is fine, but he's certainly right. It's never been produced. We did not foresee this issue.
It's a 40-page document riddled with hearsay, Judge.
It's a government record. I think probably stands on its own. It's a public government record.
Mr. Rosso, do you need time to review this 40-page document?
Judge, if I could have 1 or 2 minutes.
If I may, I think that's a reasonable question, so if I could speed it along, what I'll do is I'll hold withdrawal or wait on the motion to admit it, see if I can elicit testimony that gets the same, but it may not become an issue ultimately. But if I do want to, I'll give him notice so he gets time to read it.
Hold on 1 second.
Judge, we're ready to go.
All right. Thank you. Now,
Do you withdraw the objection then?
No, Judge. Judge, may we have 5 minutes to just look through this document real quick?
Yes.
Okay.
fine.
We'll stand at ease for 5 minutes.
Okay, so Mike, I'm going to go to you first because I want you to explain kind of what are we seeing here.
So this is what you would call redirect testimony. After the cross-examination, the lawyer calling the witness gets to ask more questions. It seems like Rusty is trying to close up some holes that the defense has drilled into the case a little bit. Right now, we're taking a break because Mr. Hardin has introduced a document that has not previously been tendered.
Is a government document, can it be hearsay?
So a government document can be hearsay. So, again, for the listeners, quick legal lesson, hearsay is an out-of-court statement that is offered for the truth of the matter asserted, right? So whatever that statement says, again, I used it rained yesterday. If the statement is it rained yesterday and I'm trying to say, therefore it rained yesterday, that's hearsay. But there are a bunch of exceptions. Even though it's hearsay, if it's one of these exceptions, it comes in even though it's hearsay.
And a government document is one of
And
those.
a certified government document is one of them. So I think Rusty Hardin is right that it's admissible even though it's riddled with hearsay. As Mr. Oso said, I like that little flourish. As a trial lawyer, anytime you can be a little snarky, that's fun. I get what he's doing there. But because it hasn't been previously tendered, so again, this isn't an exactly a criminal trial, but under the rules in a criminal or criminal-ish trial, the idea is that the defendant should have full access to all the evidence so that his lawyers are not ambushed. And as Mr. Hardin said, this had not been tendered because they didn't think this was going to come up. This is obviously in response to something.
Well, this is because it's because they brought up the whole thing about Trump, right? I mean, that Trump had signed this executive order a week later, so they're having to kind of.
That seemed to come out of nowhere.
Right, they're having to deal with that.
And and he said we had to deal with this during lunch.
Right.
They had to go out and find this and sort of hold it up to, if there were any holes poked, they want to put this right over that hole and say, no harm done.
This explains that.
That explains.
You were misled, jury, a few minutes ago when the defense tried to insinuate this or that. That was misleading, and here's the document that shows that. So that appears to be what he's doing. The defense has asked for 5 minutes because this is a big document and they want to review it. I found it interesting that Mr. Hardin then came back and said, you know what, Judge, I can save us all a bunch of time. I always think anytime a lawyer on either side does that, that's kind of a masterful lawyer move.
He reminds me of Matlock.
He does, and in the best
I'm
possible way.
showing my age here.
No, I'm with you. In the best possible way, because he's signaling to the judge, I can help you, and then he's signaling to the jury, I don't want to prolong this. I'm not going to waste your time like the opposing counsel is doing.
Like they're doing.
Right, which is, whether that's fair or not, that's kind of the insinuation. Both sides are going to score their points where they can. And so I found it interesting that the defense still said, no, we want to look at this document, which basically, again, I would worry if I was them that I just signaled to the jury, no, I'm willing to waste your time, even though he's willing to save your time.
Right.
So
But this is not a traditional jury.
Right.
No, and you also don't want to risk in that 40 pages there being something that's going to bite you in the butt. And,
Sure.
The defense is not going to risk that at
Sure.
all,
Right.
even in the slightest seemingly inconsequential thing.
Every lawyer's different. What I would do is I would try to signal, and I would say it straight to the jury, frankly, I don't want to waste anybody's time. Sure, we can go forward. Because ultimately, you are going to be able, this trial's not going to end in 5 minutes.
Right.
Right?
I mean, you could read it and let things proceed, right?
And then you could come back tomorrow, and frankly, again, this is why I would do it this way. Then you get to say to the judge and jury, Rusty Hardin misled you. We hadn't been able to read this, but now I've got this perfect comeback that's in these documents, and he's lying to you. You could kind of play that card.
You can't trust anything he tells you.
Exactly.
Right.
And so, you can always, again, when a witness has been done, is finished with their testimony, the judge will generally say, may this witness be excused. When they're excused, they're gone. But you can say subject to recall. So again, the defense can always say, hey, this witness needs to be on call in case I need to bring him back after I have a chance to read this big document.
Right.
What do we think of letterhead gate?
That seems like a lot of nothing to me.
It seems like a lot of nothing to me. Every organization I've ever worked for has more than one letterhead because letterheads are used for different purposes by different people in the offices.
Right.
And
I feel like there's a reasonable explanation
I
for this
think
that we
there's
have
a
not heard yet.
reasonable, and that it will turn out to be a nothing burger because there are all sorts of possible explanations for
And
it.
from a defense standpoint, I completely can see what they're doing, right?
Right.
You want to poke any hole in the water balloon you can and hope that's enough. And you're also trying to draw the prosecuting attorneys
Right.
away from their case and have them start answering you tit for tat. Because once you can draw the other side into answering you tit for tat,
Particularly on
they're
some
playing on
rabbit
your
trail
ground.
like this.
Exactly.
Yeah.
So if I'm Rusty Hardin and Dick DeGarrett, one of my big concern is this really worth, do I feel like that really resonated with anybody? And therefore, okay, if I'm worried about that, then sure, let's issue up this lettergate thing.
This was a coup thing.
Right.
That they took their boss's name off because they were going behind his back and they were disloyal and traitors. That's part of where this letterhead thing
that's
is.
clearly the theme, right?
Right.
I mean,
Yeah.
that's the whole thing about.
Right, and the letterhead thing is part of it. You took his name off this letter.
Well, and there's obviously they're gonna. I would almost lay odds that in the closings, this whole "there are no coincidences" in Austin.
It's going to show
Oh,
up.
that's going to be in it.
It's going to be a theme.
For a lawyer to quote his opposing or his co-counsel in some cliche that didn't really land yesterday and do it again.
It's coming back.
Right. Someone clearly said, all right, we have to work in that saying. Let's try to do it every day.
Just like I think it was obvious that Oso had a locker room talk from his coaches during the lunch break.
He was definitely more effective.
He came
his
back.
pacing was better. He was more aggressive. Now, frankly, I think he was, at times he was signaling with the tone of his voice and his kind of aha that he had scored a big point when I don't feel like he really had. But I'll give him A for effort. He was in there more alive.
Okay, we're back.
Mr. Osso,
Your Honor, I have no objection to this exhibit. Just for clarification, it was House Exhibit, what's the number, Rusty? No objection to House Exhibit 652. Excuse me, 632.
no objection to 632. Do you want to admit it into evidence?
Yes, please.
Okay.
All right.
House Exhibit 632 is admitted.
If I can, I'm going to walk up to you and I'm going to show you a page. By the way, I mistakenly called this a confidential document. I've looked at it. It is not. It is a public document. There's nothing confidential about it. That's one of 230 mistakes I'll make during this trial.
Objection.
Okay? So now, thank you.
Object to that sidebar.
Excuse me, what is the
Move to strike.
objection?
Sidebar, and I just moved to strike Mr. Hardin's comments.
Yeah, sustain.
Thank you.
You know better than that. There you go.
That makes it 237. Thank you. I'm going to walk up. I'm going to show you where the tab. I'll show counsel where I'm pointing it to. I'll go by him, show him what I'm about to address you to, because I can't send you to a page number. Just a second. Now, on Exhibit 632, is there a provision of it, and I showed you a tab, so there's no secret about this. Is there a provision in this document that you relied on in coming to your conclusions that you presented in your first draft to the Attorney General?
Yes.
And shown in Exhibit? Can you explain? And I don't know that, Stacy, you don't have this loaded, do you? Do you really? All right. Let me show you where I'm going, Stacy, because again, I don't have a page number. May I approach her? Now, if you would, on the screen that she's already anticipated, is there somewhere on this screen that you can direct the viewers to that has any language that you used as a basis for your original opinion that you delivered to the Attorney General on that Saturday afternoon?
Yes, the very last bullet point, residential and commercial real estate services, including settlement services.
And what did that mean to you?
We interpret that in the original opinion.
And then can you read the portion of Exhibit 112? Stacy, can you split it for me? 112, in your opinion, that was really based on this segment, this one little excerpt out of 632.
Yes. Second paragraph, second page. A court's main objective in construing the law is to give effect to the intent of its provisions. And then we footnote, and there is no better indication of that intent than the words that are chosen. Then we footnote, where text is clear, text is determinative of that intent.
Microphone. All right. Keep going.
One dictionary defines a service as work that is done for others as an occupation or business. Real estate is defined as land and the buildings and permanent fixtures attached to it. Thus, real estate services include services performed for others as an occupation or business that pertain to land or the buildings and permanent fixtures attached to the land, insofar as the performance of auction or foreclosure sale services related to commercial or residential real property. Such services are one specific iteration of residential and commercial real estate services.
All right. So, to reduce it down to its basics, in recommending or in your drafting to the Attorney General, saying that there should be no restriction on the foreclosure sales, did you rely on a government document as guidance as to why it would be considered an essential service or activity that was exempted based on the governor's executive order?
Yes, the specific government document referenced and incorporated into the governor's order.
All right. So in effect, in y'all's opinion at that time, was your recommendation that it would be open and they could have foreclosures based on a combination of the governor's order, and if you go to the basic item that they're referring to in the governor's order, that would have said essential services that would have included foreclosure sales for either commercial or real estate property?
Yes.
Residential property, excuse me.
Yes, we conclude that it is not, there's no occupancy limit applicable pursuant to Executive Order GA-28.
Now, when you then were directed to come to the opposite conclusion in the drafting, that is the final product in the exhibit that we've been using, I think is 115, you had a challenge to write around the basis for your first opinion, so what did you do?
Objection to leading and assuming the answer in the question.
Sustain, rephrase.
What did you do to come up with the opposite conclusion you had originally arrived at?
A couple of things. If you go to page 2 of Exhibit 115, we first point to the general occupancy limitations in the 3rd paragraph. Next, we do point ultimately to CISA at the bottom paragraph. And if you would go to the next page. At the very bottom of the first full paragraph, and this is really the kicker, the court's main objective in construing the law is to give effect to the intent of its provisions.
Slow down, please. On behalf of court reporter.
Yes, my apologies.
And the volume on behalf of the people on the floor. Could you speak a little louder, please?
Yes. We repeat our commitment to textualism, which was a guiding star of our office at all times. We then point out that based on our analysis of the words, we believe that outdoor foreclosure sales, last sentence, are not exempted from the 10-person attendance limitation.
And
we completely reversed it.
Excuse me, I'm sorry. What was the only thing that had changed since you had the original opinion?
The direction from the Attorney General.
All right. Now, you had questions about whether or not it would have happened anyway because of other subsequent events. At the time that you drafted these 2 opinions, did you have any idea that Nate Paul had bankruptcy hearings scheduled?
Objection asked and answered. And this witness said he didn't have specific knowledge, so speculation.
Sustained.
In this particular matter, did you yourself know about any bankruptcy hearings that were set any foreclosure hearings that were set in the foreseeable future? Just you yourself, were you aware?
Objection asked and answered.
Not by me.
And lacked specific knowledge.
Overruled. I sustained your first objection, which forced him to ask the question a second time.
Thank you, Your Honor. Did
No.
you yourself?
I had no specific knowledge of any specific foreclosure sales.
All right. You were there when he introduced a certain document. And if I can I have Exhibit, AG Exhibit 295, please, Stacy? You heard earlier questions on direct as to whether or not, have you not, sir, these opinions would be of help to somebody who was somebody that was opposing a foreclosure hearing, right?
I recall those.
All right. Now, if you could, can you identify, had you seen before we showed you this Attorney General exhibit, had you seen it before, this exhibit that he's entered into evidence?
No, this is the first time I've seen this document.
All right.
With the cross-examination.
All right. Now, I want you, I'm going to read this to you and ask you what the import of this when you look at the exhibit is. Judge Gamble, August 3rd, 2020. As it is relevant to these proceedings, please see the attached guidance just released by the Attorney General's office. Had been just released, hadn't it? What date was it released?
The 1st.
1st of August. That was a Sunday, was it right?
I believe midnight the 1st. I think that's right, yes.
So this is just Tuesday after you released the opinion on, or after you provided the Attorney General the opinion on Sunday the 1st, correct?
It's 2 days later, yes.
Keep your voice up away from the microphone.
2 days later, yes.
All right. Regarding the foreclosures may not proceed unless specifically authorized by the mayor and the city of the foreclosure, given the standing 10-person restriction would violate Texas Property Code, Chapter 51. Does the attachment include the opinion that we have just been so laboriously going over?
Yes.
Would you look to the last page of that opinion and see if that's the final one that we identified as Exhibit 115?
It is.
With your signature?
It is.
does the cover page identify on behalf of whom this particular email, excuse me, this particular pleading was filed in a court here in Travis County?
Yes.
And who was the person that represented whom was presenting this particular pleading and urging that your opinion was relevant to their case?
This is one of Nate Paul's companies.
Do you even yourself personally know how the judge ruled one way or the other on this motion?
Not in this case, no.
All right. And in fact, are you familiar with any other cases Nate Paul cited this opinion and seeking to foreclosures in that year of 2020 after you rendered your final opinion?
Only through news reports that came out after.
All right. Was it multiple places?
Yes.
Objection to hearsay, Judge.
I'm through.
Do you withdraw that question?
Yeah, I think actually he meant to say leading. It was leading, it wasn't hearsay.
No, I meant to say hearsay, but I'll retract the objection for Mr. Harden.
That's all I have.
Recross?
Yes, Judge.
Mr. Rosso?
You just cited the Cybersecurity and Infrastructure Security Act pretty precisely to Mr. Harden on direct examination, did you not?
I had it in front of me.
Okay. You also cited the day of the week that you issued that opinion, did you not?
The day of the week was August 1st when we issued the opinion.
I'm just surprised because you showed an uncanny ability to remember things when Mr. Harden was asking you questions, as opposed to when I asked you about the same documents during my cross-examination. Can you explain that?
I disagree with your characterization.
Okay. We'll agree to disagree. I don't have an e-copy of this CISA document that the House has just produced, but I think Mr. Harden had you reference page 16 of that document, did he not?
He did.
He had you reference the very bottom part that I have highlighted in orange, and I'm going to show the jury. And it says settlement services, correct?
One of the things it says is settlement services.
Now, behind the term settlement services in this document, there is no definition as to what settlement services are.
I do not see a definition.
I don't see the word foreclosure sale or non-judicial foreclosure sale behind it, do you?
The word foreclosure sale does not appear.
Do you have a real estate license?
No.
Okay. Would it surprise you to know that people that have real estate licenses oftentimes engage in settlement services to close on homes?
I would not know.
It deals with title work and things of that nature?
I would not know.
Okay. You won't find the word foreclosure sale in that definition, sir.
This definition? It is not in, the word foreclosure does not appear there, but that's why you engage in legal analysis and construction.
Legal analysis and construction, which means that somebody else, another attorney, perhaps the Attorney General, could have a different viewpoint as to what a settlement service is, correct?
He could have any number of viewpoints about that.
That's why they call it the practice of law. Zone of reasonable disagreement. That happens a lot in law, does it not?
Not in this case.
Okay. Well, that's your opinion, but let's talk about facts. Are you aware of whether or not the opinion that you wrote that you said was unconscionable and opposite of Attorney General policy, did anybody challenge that in a court of law?
Did anyone challenge the opinion?
Yeah, the opinion in a court of law.
I'm not aware of it being challenged. I don't know how you would do that under standing doctrine.
Okay.
The witness may step down.
have one more question if the court would entertain it.
Will the witness come back? One more question.
Prior to your term as a politician, did you or did you not practice real estate law? No. Paxton practiced real estate law, did he not?
I believe he had some real estate experience back in his past.
Okay. So when you guys are going back and forth regarding the definition of things, it's possible he had some background knowledge of what settlement services meant?
In this case, that was not the best interpretation.
Okay. That's your opinion, sir, correct?
No, that's the law.
That's your opinion.
I disagree.
Okay.
You may now step down. House, call the next witness.
We call Mr. Ryan Vassar.
Yeah, please do.
Mr. Vassar, were you sworn in the other day in the group? Okay, I need to swear you in. Please raise your right hand. I do solemnly swear or affirm that the evidence I give upon this hearing by the Senate of Texas of Impeachment, charges against Warren Kenneth Paxton Jr. Shall be the truth, the whole truth, nothing but the truth. So help you God. You may be seated.
Good afternoon.
Good afternoon.
Mr. Vassar, you and I have met at least once or twice, correct?
Yes, sir.
But I don't think we've talked about this subject. And that is, we have some microphone issues that you and I have to worry about. If you will try to make sure that you're speaking into that microphone to where everybody in the back of the room would hear, and I will try to make sure that I don't talk on top of you, and we go from there, okay?
Yes, sir.
Your full name?
Ryan Vassar.
That's going to work, if you can just stay with that. How old a man are you?
I'm 39.
And you married?
I'm married.
How many children?
4 kids.
How old? What ages?
Ages between 3 and 7.
Wow. In 2020, how old were they?
I had a 6-month-old, a 2-year-old, a 3-year-old, and a 4-year-old, I believe.
How are you employed now?
I'm general counsel for a local nonprofit organization in Austin.
When you left the Attorney General's office, and we'll get to that, how long were you unemployed before you found a place to land?
6 months.
What was your source of income?
Savings, but I was not employed as a lawyer for that 6-month period.
Did your wife work outside the home?
No, sir.
Let's go back now, a little bit of an autobiographical sketch review for about 1.5 minutes if we can. I'm not going to time you, but just roughly. Like where you grew up, your parents, what your background was?
I grew up in Big Spring, Texas, a small town in West Texas. I'm the oldest of 3 siblings. I attended Texas Tech University and majored in accounting. My father and grandfather are both certified public accountants. They both attended Texas Tech. They've had a CPA practice in Big Spring for the past 40 years, where they serve 3 generations of farmers and ranchers and salt of the earth people.
So how many years has your family been living in Big Spring?
My whole life.
All right. Now, when you finished as an accountant at Texas Tech, what did you do?
I moved to Dallas and worked in finance for about a year and decided I wanted to go to law school.
And so I started working at Jones Day as a litigation assistant and during my application periods.
Does litigation assistant mean a runner?
Essentially, yes, sir. I was in charge of the documents.
And did you clerk or get to know anybody else of the legal profession while you were there? Other than the lawyers at Jones Day?
No, sir.
All right. Now, and then after you graduated, what year did you graduate from law school?
Law school was December of 2012. I'm sorry, December of 2011.
2011. And Mr. Vassar, were you involved in any outside, either political or social activities in addition to going to college and law school?
I was a member of the Federalist Society for Law and Public Policy Studies while in law school. And then I interned for 2 federal judges, one on the Southern District and one on the Fifth Circuit.
Which judges did you intern for?
Judge Lynn Hughes on the Southern District, and then Judge Jennifer Elrod on the Fifth Circuit.
And those were both college, law school internships, correct?
Yes, sir.
Were you involved in Republican politics at that time?
Not at the time, no, sir, other than just typical voting.
All right. And then after you finished law school, what did you do?
I served in Governor Perry's office of general counsel as an attorney fellow.
How long did you do that?
It was, I think, 6 weeks. It was a summer.
And then what?
And then I was invited to clerk for Justice Don Willett of the Texas Supreme Court.
So Justice Willett was on the Supreme Court. How long, to your knowledge?
How long had Justice Willett been on the court?
Yes.
He might have been appointed by Governor Perry at the time, maybe around 2010 or sooner.
I haven't sought to introduce it, but is it a fair statement that Justice Willett had a extremely complimentary letter for you to have you go off and seek employment elsewhere when your service was over?
Objection, sir. Relevance.
Right.
Sustained.
Right. Now, at the end of the day, how long did you work for Justice Willett?
3 years.
And was that always exclusively on the Supreme Court, or did you work for him after he went to the Fifth Circuit?
Just the Supreme Court.
Now, at the end of those 3 years, what was your internship supposed to be? How long was it supposed to last? Your clerkship, excuse me.
Right. Justice Willett had asked that I commit to 2 years. 2 years came and went, and he said I could stay as long as I wanted to. But just with the circumstances that had changed, when I joined the court to work for Justice Willett, I was single. My wife and I got married while I was working there. And then about 1.5 years later, we were pregnant with our first kid. So I think it was just a necessary transition from the court to other opportunities.
Right. So where did you go to work after clerking for Justice Willett?
I joined the Office of the Attorney General.
And who interviewed you? Who hired you?
Amanda Crawford, at the time, was the division chief of the General Counsel Division.
And what year was it that you joined the Texas Attorney General's office?
It was July of 2015.
You recall what your first assignment was in the office?
No, sir, I don't.
Okay. And then as time went on, by the time we reached the period of 2019, what was your position?
2019, I was chief of the General Counsel Division.
What does that mean? What would your responsibilities be?
So I advised the agency as the General Counsel, whether it was employment matters or contracting matters, state procurement law, just the typical day-to-day business legal advice.
And then as you went along there, and did you continue to move up within the organization?
Yes.
When was your next promotion?
It was April of 2020.
Now, was Attorney General Paxton already the Attorney General when you joined the office?
Yes, sir.
So your entire career at the Attorney General's office was under the guidance and service of General Paxton?
Yes, sir.
How well did you get to know him?
I might have met him for the first time at an office Christmas holiday party where he and Senator Paxton were taking photographs with employees. That might have been 2 years into my my employment, so maybe around 2017. From then until I was promoted to deputy for legal counsel, I might have seen him once or twice at a division chief's meeting, but nothing.
And then what about by the time we approached, let's say, January of 2020? How much contact by that time in your different positions that you had with General Paxton?
He might have contacted me once about a matter, but other than just the typical monthly division chiefs meeting or holiday party, it was nothing substantive.
All right, so we in the jury and the court assume that you yourself did not personally know Mr. Paxton that well at the time.
That's correct.
All right. Were you around him socially other than a periodic office gathering?
No, sir.
All right. Now, when we enter the year of 2020, whom did you have under your supervision in the office?
April of 2020, I was promoted to be the Deputy Attorney General for Legal Counsel.
Does that mean that you were one of the top 8 deputies, or 12 deputies rather, up on the 8th floor?
Yes, sir.
Would you describe, I'm not sure we've broken it down to people, when we talk about the 8th floor, what does that mean in common vernacular for you?
So the 8th floor refers to the 8th floor of the Price Daniel building, where the majority of the executive staff of the Office of the Attorney General have offices.
All right, so when we talk, if the jury is to hear about people where General Paxton dropped into this person's office, this deputy's office, that deputy's office, were all of these offices along the same area, or what was the physical layout?
So if you can imagine, there's 2 elevator banks in the middle of the building, the middle of the floor. And the offices are spaced out around the perimeter of the inside of the building. So each deputy would have an office. There were roughly 3 or 4 offices on one span or one length of the building. So each deputy would have an office.
So my reason for asking, and I'm asking you the answer to this, is that where the office is readily accessible to each other and to the Attorney General, where any of those folks were within a very short distance on the same floor of dropping in or out on each other?
Yes, sir.
All right. Now, when did you first hear, if you ever did, of a person named Nate Paul?
I think it was May of 2020.
And what was the occasion for you to first well, let's back up. What was your position in May of 2020?
I was Deputy Attorney General for Legal Counsel.
Now, how much contact did you have with Mr. Mateer?
We had weekly meetings, one-on-one meetings with Mr. Mateer, Mr. Bangert, and myself.
Now, you're dropping off. I want you to remember that microphone, and maybe you need to move up just a little bit, or... All right. You had these weekly meetings, staff meetings, where there's a day scheduled of the deputies and Mr. Paxton?
So there are deputies meetings that occur weekly, and then there are also one-on-one deputy meetings with Mr. Mateer. So I would meet in all of the deputy meetings, but then I would also meet individually with Mr. Mateer and Mr. Bangert.
And at that time, how old were you?
I would have been 37 or 36 at the time.
And you would have been there at the Attorney General's office since you were about 32 or so?
Yes, sir.
Would you agree that you had moved pretty fast in the organization?
Objection leading.
Sustain.
Sure.
You asked differently.
Yeah. Now, at the end of the day, when you entered into, say, your new position as Deputy General Counsel, what type of matters would that have put you primarily over?
So the Deputy Attorney General for Legal Counsel oversees the opinion writing process, the Open Records Division, the Public Finance Division, the General Counsel Division, and I believe that's it.
All right. So in May, or April or May of 2020, what was the occasion with you becoming familiar with the name of Nate Paul?
There was a pending open records matter involving the Department of Public Safety that had been connected to Nate Paul's name.
Now, at this time, how well did you know Mr. Mateer?
I believe Mr. Mateer joined the office in 2016, if I'm not mistaken. So I'd become familiar with him just in my experience over the past 5 years working at the agency.
What was he like as an administrator and first assistant?
He was great. I mean, he was a people person. He wanted to know how staff were doing. He wanted to connect with each person. He was invested in what they were doing, what they were interested in. He would host book clubs where he would select a book, whether it was a managerial book or leadership book, and we'd meet over a brown bag lunch and just talk about a chapter of the book and how we can implement it in our work and at home. So he was a role model.
Was he religious?
Yes, sir.
How about you?
I am.
In what way?
Objection, relevance, Your Honor.
It's very relevant to who these people are in the light of who they've been accused of. Thank you.
My wife and I attend an independent Baptist church here in Austin. We've been members at different churches here in Austin, and I've been a member throughout my life.
What did you view your duty as an assistant AG to be?
Assistant AG, or as far as Deputy Attorney General for Legal Counsel, I was responsible for providing legal advice to the agency through the various functions of the divisions, whether that was the Open Records Division, the Opinions Division, the Public Finance Division, or the General Counsel Division.
You've heard, have you not, or have you heard, you're being referred to by the Attorney General, all of you, as rogue employees?
Yes, sir.
What was your reaction when you heard that allegation?
It was hurtful.
Why? Tell me.
Sorry. I worked for the state for 8 years as a public servant, as one who values.
Your Honor, may I approach the witness?
Yes.
Thank you. As one who values the commitment to public service, to set an example for my kids, the people that I worked with, the people that I managed, and it's contrary, the statement of being rogue is contrary to the years that I dedicated my life to the state.
How did you become familiar with Nate Paul?
Well, as I mentioned, the first time that I had heard the name was connected to the open records request that was pending at the agency, the Office of the Attorney General, involving the Department of Public Safety.
And did you learn what the issue was about this open records request?
Yes, I did.
And what was the issue?
The Department of Public Safety had received a request for public information. Under the Public Information Act, agencies that desired to withhold information for a valid purpose have to ask for the Attorney General's ruling on withholding information within 10 days. The Department of Public Safety had requested a ruling from the Attorney General's office on whether it could withhold information under the law enforcement exception to disclosure. So in other words, if there is information in the request that qualifies as law enforcement information that is not required to be disclosed, the agency is requesting the Office of the Attorney General to make that determination so that that information can be withheld.
At the time that you began to have awareness of Nate Paul, how would you describe your sense of loyalty and support of the Attorney General?
It was my understanding that General Paxton had met personally with Nate Paul. He considered what had happened to Nate Paul to be wrong, and he wanted us to find a way to help Nate Paul.
And when was the first time? Did you have conversations with the Attorney General about this matter?
Yes.
When did personal conversations with the Attorney General begin in person? Either, well, let me put it in person or by phone or by text, any of that way. When did you first have contact of some type with the Attorney General about Nate Paul?
It was in the month of May of 2020.
And what form did that take, and how did it happen?
I believe it was all in person. There were no phone calls or text messages or emails, to my knowledge.
All right. And when they had these phone calls, do you recall what the Attorney General said in the first one and what the occasion was for that call?
The initial call was a request to pull the file, basically.
By whom? Who asked you?
General Paxton.
Do you recall what he said on the call?
Well, I say it wasn't a call. It was generally in person.
Oh.
So stopped by the office, asked me, I would like to see this file. And so I contacted Justin Gordon, who is the chief of the Open Records Division, and asked him to bring the file to my office.
Now, at that time, had you had any contact with Nate Paul's case yet? Or was the General Paxton's request of you the first time you had become involved?
That was the first time that I was involved in the DPS file, the request at that time.
So, did you get the file?
Yes, I did.
What did you do with it?
I reviewed it and notified the Attorney General that I was prepared to meet to discuss it.
How did you do that? How did you notify him?
Normally, it would have been an email to his scheduler, just to see if he was going to be in the office, to see if we could schedule a time to meet. I don't recall specifically if I emailed the scheduler or contacted his aide.
All right. Did you, when you reviewed it, what all did you do? I mean, how much time did you spend reviewing this file?
It's my recollection, everything was drafted. The initial draft of the ruling was already complete, and it was a standard law enforcement exception was raised, law enforcement exception applies, the information should not be disclosed. So it was a pretty straightforward review.
Did you learn one way or the other whether there had been a previous ruling and finding from the department as to whether or not the law exception applied to the same event that was now happening with DPS?
Mr. President, I believe the objection would be this question calls for the solicitation of hearsay.
I don't agree it's leading, but I'll withdraw it because I don't think it was understandable. So I'll take it back.
For all the questions.
Thank you very much. So let me ask you this. When you reviewed the file, did you find out anything about whether or not, what event was being complained of that they wanted access, whose files they wanted access to?
The subject of the event was the August 2019 raid of Nate Paul's home and businesses.
All right. When you reviewed the file, did you find out one way or the other whether this issue had come before the agency once before about the file on the same event?
At the time, I did not connect this event to any previous determination by the office, but subsequently, I did connect the two.
All right. So ultimately, did you discover or connect, as this was the second time around for Mr. Paul and his attorneys seeking information to overcome the law enforcement exception?
That's right.
Objection leading.
All right. Now.
Sustained.
All right. Now, let me ask you this. After you reviewed the file and you informed the Attorney General you were available to meet, was there a meeting?
Yes.
And can you put a time area for us as to when this meeting occurred?
It was in the middle of May, and the reason that I believe that it was between that period is because when the Office of the Attorney General receives an open records request for a ruling, the office has 55 days, up to 55 days to issue that ruling. The DPS ruling was due June 2nd. That was the 55th day. So we would have been discussing it in the middle of May before it was released on June 2nd.
Now, you made a minute. Was there already a draft opinion regarding the matter that was intended to be issued before July 1?
Yes.
Or was it June 1 or July 1? I've got...
June 2nd was the 55-day deadline.
And what was the preliminary opinion that already existed in the file when you started looking at it?
It was to withhold the information under the law enforcement exception.
Now, when you told the lieutenant, the attorney general that you were available, how soon did you meet with him, if you did?
It would have been a matter of days between notifying him and scheduling a meeting in his office.
You met with him in his office?
Yes.
All right. Was anybody else present in the meeting?
There were a series of meetings at which Justin Gordon, the chief of the Open Records Division, and Ryan Bangert attended.
All right. So at this first meeting, were they both present?
I don't recall if both were present, but there were just in this meeting and the subsequent meeting, they were both in attendance at one or the other.
What did the attorney general say in this meeting?
He asked us to review the file. He asked us what our interpretation of the file was. He told us that he had spoken personally with Mr. Paul. He said that he believed that something bad had happened to Mr. Paul. He felt that Mr. Paul was being railroaded by the FBI and by DPS. And General Paxton said that he didn't trust law enforcement. He asked us to find a way to release the information that had been requested to be withheld.
And in your experience and your familiarity with the subject, what was your response to that?
Objection, hearsay.
It's not. This is the witness. This is his
Overruled.
response. Thank you.
I told General Paxton that if we were to reach the opposite conclusion and to require the Department of Public Safety to release the information, it would upset decades of precedent involving the law enforcement privilege, where law enforcement agencies rely on the protection that the Public Information Act gives it to protect ongoing information, to protect confidential information, to protect witnesses who could be compromised if their names or their identities were released. So there's incalculable problems with reversing the decision to withhold the information and require it to be produced, not just across the state, but with the Office of the Attorney General.
Mr. President, if I may, a lot of this is in narrative and not responsive to the question.
That is exactly responsive. I object to this.
Just state the objection, but sustained. Go ahead.
Thank you. What was your opinion, based on your experience, as a potential danger to innocent citizens who had cooperated with the police, thinking that would be confidential?
It could silence people who might ordinarily comply or speak to the police if suddenly their names or identities could be released.
So what was the Attorney General's reaction when you told him all? But first of all, the stuff that you just said, is that essentially, in a sense, the information you gave him in explaining what your position was?
Yes, sir.
Did anybody else speak up as well?
Objection, hearsay.
I asked if anybody else spoke up. That is
Overruled.
Thank you. Did anybody else speak up?
Ryan Bangert also spoke. I don't recall exactly what he said, other than that.
And what was the Attorney General's reaction to all this?
He, again, insisted that what had happened to Mr. Paul was wrong and that he didn't trust law enforcement.
And did he make any distinction about which agencies, or did he talk about all law enforcement?
It was specifically the FBI and the Department of Public Safety.
And did he say why he didn't trust them?
He said that he compared what had happened to Nate Paul to General Paxton's own personal situation involving the Department of Public Safety and the State Securities Board and the FBI.
Well, were you aware of who provided his security?
Yes, sir.
And who was that?
The Department of Public Safety.
Did he indicate in his comments what his level of feeling or trust or distrust about them was?
Not to me.
All right. Now, how long did he, when you expressed what his initial opinions were, did he go any further, or how did the conversation proceed?
He asked me if he could obtain a copy of the DPS file.
Had you ever been asked or know of any other time where the Attorney General had asked to see a particular file that it's a public information request for?
No, sir.
So what did you do?
I said that it was possible for him to receive a copy of the file.
And I believe you said this was around May 15th, did you not?
Yes, sir.
Did you provide him the file?
Yes, I did.
Did it have everything in it?
Yes, sir.
Did you take anything out of it?
No, sir.
Can you tell us whether or not in that file you had, there was any brief from the FBI weighing in as to their materials in the file and their position as to whether it ought to be released?
Yes, the FBI had submitted a brief in response to the DPS.
So you say they're doing the cutting right now? Where's that?
Yeah, it's the BI.
Within your department, if you have a request for open records, people want to get some portion of it from another agency. What was your policy as to let the other agency weigh in?
The Public Information Act requires.
So you say they're doing the cutting right now? Where's that?
Yeah, it's the BI, Reader's Invitation. That's the one with the biggest
information
cut
that
for
gets
shows.
that they have a right to
Is that going to be
to submit a letter ruling or a letter brief to the Office of the Attorney General for consideration.
So in these circumstances, would it be normal or unusual for y'all to have notified the FBI there was this request, that the request was to an agency whose files included FBI materials? Would it have been usual or unusual for them to let them know so that they could respond if they wanted to?
So in this situation involving the DPS request, the Department of Public Safety did notify the FBI that its information may be at stake in this request for a ruling. And the FBI responded by submitting a letter brief to the Office of the Attorney General under the ordinary principles of the statute.
Were you aware through these materials and looking through the file that there was an ongoing federal investigation of Mr. Paul at that time?
Yes, it was clear.
Did you take a position with the Attorney General that there was an ongoing, at least federal, I'm not including right now state because I have no knowledge one way or the other, but that there was at least a federal ongoing investigation of Mr. Paul that release of these documents would interfere with?
Objection, leading.
Sustained.
Did you inform him one way or the other about, did you have discussions with him concerning the topic of an ongoing federal investigation?
Yes.
And what did you tell him and what was said?
It's my recollection that there were discussions about the substance of the brief that the FBI had submitted, the quality of the arguments that they had raised and made.
And did this brief provide details of the ongoing federal investigation?
Objection, that will solicit hearsay, Your Honor.
No, I'm not asking for communication. I'm just asking whether or not it contained details about it.
May I be heard on that?
Yes.
Mr. President, so Mr. Hardin is asking the witness about the contents of some other document that is not currently in evidence, pretty much right down the fairway of hearsay.
I'm not asking for
specifics. I'm going to sustain, rephrase your question.
Well, I'm not asking you for specifics of what it said. I am only saying, were there documents and information in this file that that were used as the basis of a conversation with the Attorney General concerning the presence of an ongoing federal investigation of Mr. Paul?
Yes, sir.
All right. Now, when you gave the file to him, how did that happen? Did you go to his office? What did you do?
I believe I delivered the file to Andrew Wicker, who was General Paxton's aide at the time.
And did you later confirm that Mr. Wicker gave it to the Attorney General?
Yes.
And how long was it? Will be some intervening events I'll ask you. Well, how long was it after that event that you retrieved your file from the Attorney General?
Well, as I mentioned, when the Office of the Attorney General has to make a ruling, it's on the clock. So we have a timeline. I was notified by Justin Gordon, the chief of the Open Records Division, that we needed to make a decision because the clock was coming up. It was approximately 7 to 10 days before that when I delivered the file to Andrew Wicker, and Mr. Gordon had emailed me asking for a status update.
And so then how long after, back to the original question, was it from the time you gave it to the Attorney General to you? Let me ask you this, was it ultimately returned to you?
Yes, it was returned to me.
And when was it returned, approximately when was it returned to you?
I believe it was May 28th or May 29th.
All right. And in the meantime, were you part of any later conversations after the one you just relayed, in which you expressed your opinion, the Attorney General expressed his? Well, let me back up. In that second meeting, counting the first meeting being him asking you to look at the file, okay? The second meeting would be the one we just discussed. In that second meeting, did the Attorney General give you any indication as to what he wanted you to do?
Well, he wanted us to find a way to release the information.
And after you expressed yourself, Mr. Bangert expressed himself, the Attorney General expressed himself, in that second meeting, was there a conclusion as to what was going to happen?
No, sir, not that I recall.
All right, how did the meeting end up?
We were essentially at an impasse on our recommendation not to release the information and the Attorney General's decision to release it in some form. We told the Attorney General that we would review our options and follow up with him to see if there's anything else we can look at.
What was his position as to whether or not he wanted or thought the law enforcement exception should apply?
He didn't necessarily take a position that I recall other than something happened to Mr. Paul, it was wrong, this shouldn't be allowed for the FBI and the DPS to get away with.
All right. Now, after that, when was the next time you had any contact with the Attorney General on this matter?
Again, it probably was a matter of days after that, just in light of the timeline and the deadline. We followed up and let General Paxton know that we looked at it again. We didn't think that we could reach an alternative conclusion.
And who was the we in that part?
Ryan Bangert and myself.
And how did you let the Attorney General know?
We met in his office.
And do you recall when this third meeting was?
I believe it was toward the end of May.
And
Counselor, not to interrupt, we're a little past our mid-afternoon break. Is this a good spot, or do you want to go?
This is
You're fine here?
Sure.
Okay. We'll stand in recess until 3:30.
Okay, guys, so that was some fascinating testimony from Ryan Vassar. I thought, it was particularly interesting when he's asked, how did you make you feel? I don't remember the exact question, when Attorney General Ken Paxton accused you of being a rogue employee. And I mean, hold on a second. Ryan? Oh, sorry. All right, we're making sure everybody's mic's on, guys.
I think I am.
So anyway, and he says, and he got emotional and basically said, let me find my notes. I worked for the for 8 years for the state of Texas, and he had a commitment, and you could just see how emotional he got at that statement.
He was in tears. I mean, he started crying, talking about his kids, really, about how he wanted to set an example.
Oh, we got to turn Katie's on. Sorry, guys, we've been up here too long, and we kind of lost track of whose mics are on and whose mics are not on. Well, hey, Mike, what did you think?
Yeah, I definitely thought that he showed real emotion there. From a trial lawyer standpoint, you want your witness to look like a real human being. You want them to not look rehearsed. Any emotion, you don't want it to look like fake emotion. If somebody's going to cry,
it felt very real.
Right. You don't want the audience to feel like, oh, crocodile tears, this is fake. I felt like that looked real to me. Maybe he's a really good actor. I don't know, but yeah, that came across as real.
It did not feel like an act.
I thought he was surprised by how emotional he became.
Right.
That it caught him off guard.
Well, and I mean, look, regardless of how you feel about this, if you feel like I have an oath, I have a duty,
right.
I take that very seriously. I could be in private practice making all this money, but instead I'm committing myself to government and whatnot, and then because I did what I thought was right, I'm being called a rogue and a traitor and
and this
disloyal.
is somebody that you respect and you believe in the values of what they
share
say
the
they
values,
right.
Yeah. I think it's pretty fair to say that no one at the Attorney General's office currently or in the last 5 to 10 years is a liberal or anything like that. These folks are they all subscribe to the brand of conservatism that Paxton did, and I think that's why it especially hurts. It's one thing for somebody who's arch conservative to call a liberal, a name, that's politics, right? But when when you as the witness are saying, look, I'm one of you guys, and you're calling me a traitor.
I think another thing that came up that was, I don't mean to step on your question.
No, you go ahead.
Was the description of the Attorney General as not trusting law enforcement.
Oh boy, yeah.
That was like, say what?
Yeah.
He is the chief law enforcement officer of the state.
Yeah.
Am I missing something here?
No, I think that's a point that's easily lost maybe by the general public, because they hear Attorney General and they think, oh, he's the top attorney, but yeah, he is the head law enforcement official in Texas, and all of the senators, the jury would know that, and so when you are the top law enforcement officer, and to say that you think you have no trust in law enforcement, you have no trust in Texas law enforcement, and I thought the question about who provided his security detail by Rusty Hardin was pretty crafty, because of course it's the very DPS that are protecting his life that he is telling that people that he thinks are on a witch hunt.
And we haven't gotten testimony yet about how he was, ditching his security detail, which is going to come. I assume.
Right, it's going to come out. The
probably
Uber
when
account,
if we hear from Wicker, probably from Drew Wicker, who was his kind of his. Like I don't know if they call it a body man, but basically his assistant.
Yeah,
he was his guy.
Personal.
Right.
Yeah. He said that he felt that Mr. Paul was being railroaded by the FBI and he didn't trust law enforcement. And Vassar said he told Ken Paxton that if they reached this conclusion that would have allowed the release of these documents, this probable cause affidavit, that it would upend decades of law enforcement principle, and that is true, because the law enforcement exception, anybody that's filed an open records request knows that this is a pretty common exception.
Oh, absolutely. For a lot of reasons, privacy of people who are making complaints to the police, all sorts of reasons.
Well, and as a criminal defense attorney, I have tried to get my hands on police reports early, like any other attorney, and of course the Attorney General's office thwarts you at every turn. And so, yeah, it feels, and I think that's the point of the prosecution here, it feels especially convenient that Paxton has never felt that way in the thousands and thousands and thousands of times people have asked for probable cause affidavits.
I don't think I've never gotten any special treatment where anything I wanted was suddenly given to me.
But this person who's a donor, who's employing his mistress, who, all of a sudden that guy, that guy gets this special treatment, and that's the point, right? Of course, Paxton was quoted in that as saying he thought this was unfair to defendants and that they should have access to that. Again, as a criminal defense attorney who represents those very same defendants, I thought, oh boy, that would have been nice. And the dozens and dozens of times I've asked for exactly that and been told, oh no, of course not.
One of the things that Andrew Murr said, and he's one of the House impeachment manager that gave the opening statement. He's a Republican. He's chair of that general investigating committee that investigated these matters. And what he said on day one, and I think I got to go back to it, is that he alleged that Ken Paxton had turned the keys of the office over to Nate Paul. Mm-hmm. And what it feels like is, systematically the prosecution is showing through the testimony how that happened.
Right. Yeah, it's definitely going to be the prosecution's job to show that these extraordinary actions that were completely unprecedented were taken for the sole benefit of Nate Paul and to the detriment of the people of Texas. And if they can do that, they've proven their case. And it's going to be the defense's job to show there's nothing to see here. This is a big misunderstanding. This is a witch hunt.
It's a plot.
And if they can do that, then they can win. But so far, and I as a defense attorney implore juries all the time to please keep an open mind, and there's two sides to every story, and they get to go first. Please don't make up your mind before you hear from us. So this isn't over by any stretch. But so far, the evidence that these are extraordinary actions and that they're unprecedented and that they benefit Nate Paul, it's been pretty compelling.
And I think another thing the narrative is showing that the defense is presenting is how the gradual realization of the breadth, the width of what Paxton was asking their office to do crept up on them very, very gradually, because their office, one, is big, and it was going into different.
Well, because he didn't say, I want the foreclosure order because I want to help Nate Paul.
Right.
I mean, Paxton himself has to have been aware that what he was doing was extraordinary. And I think the way he asked for things and the way he phrased them and the way he did a little bit over here and a little bit I don't think any of that was an accident.
Well, and it was happening in different areas. There were some people like Bangert who seemed to have been touching more than one thing.
Because of his job, he had access to know more.
Well, and he had been over open records at one point, which is how he comes into contact with the open records situation, and he was involved with I think also the foreclosure situation and the Mitty Foundation. But he wasn't directly involved in Kamek, I don't think, but he was familiar with it.
But I think
because he's up on the 8th floor, he's seeing all this starting to go on. Of course, they eventually are going to have this meeting,
and that's what Mantier was talking about.
They're going to have the come to Jesus meeting, so to speak, where they're going to go.
Wait a minute. Right.
What's
been happening?
You to do that? Yeah.
Right. And again, from a criminal defense lawyer standpoint, I think it's exactly the right strategy for Paxton's lawyers to point out that didn't seem to strike you as odd at the time, and you didn't write that memo at the time, and you didn't go to the FBI right then. Trying to show that this was nothing and that you're making something bigger out of it. And again, what the prosecution is doing, and I think, again, doing a good job, is to show that it took a while for these folks to
memorialize this.
Right.
Initially.
Well, they weren't thinking their boss would do anything wrong.
Because they all, according to them, if you believe their testimony, they they bought in, right? They believed in him.
These were true believers.
Right, true believers. They love their boss, and they didn't see this coming. And so, I think watching the testimony that so far that narrative is landing.
It comes through. They feel hurt.
Yeah.
Yeah, and betrayed.
Especially, on the heels of two. You described the first witness as a little nerdy. The second witness was very polished and smart, and this third witness, although he's no slouch, he is. I think it's a good array of people. He's very personable. He had that emotive moment where he's showing real emotion. Right. I think it's a good presentation so far.
And one thing we didn't talk about before Vassar got on, but this Anthony Oso, who works in Dan Cogdell's office, it felt like he went to a bit of a master class in lawyering as he's dealing with Rusty Hardin, where he goes. Let me go back in my notes here. He says. And Hardin says, I didn't think he meant to say leading, not hearsay. And of course, Oso says, I did mean hearsay.
Yeah, yeah. Anytime one lawyer points out, your objection, young man, which was kind of the implication.
That was basically what he's saying.
Right, the unsaid
you whippersnapper.
thing. Right, you got that wrong. Let me tell you what the right objection was, and I'll go ahead and give it to you. That was the tone of it, which... Right. I found funny. Look, all these guys are good lawyers. Rusty Hardin is a legend, and I think he's showing it there. The control of the courtroom. I noticed on the feed that Dan Patrick laughed. That clearly. It's one thing to make a joke in the courtroom. Sometimes that's appropriate. Sometimes that's not. But if you can do that, make the judge laugh. And you are showing a control of the courtroom. And for a trial lawyer, so much of lawyering is being the voice in the room that the jury can trust. Mm-hmm. And that is established by, not destroying your credibility,
and think
but
how many
by
times
being in
Hardin
control.
said things like, let me help you with that.
Yeah.
To the opposing counsel or to the judge. I'll get that for you. I mean, he's being helpful to them all.
Right. Right, and that's no accident. That's no accident, right? And the times that he's gotten testy, the way he presents it is, I've just lost my patient with this young man's incessant, ridiculous objection. Right, yeah, exactly. This whippersnapper's ridiculous.
I mean, I almost
objections.
felt like I could hear him say it.
Really, right, yeah. And look, Oso is defending his client, and he is lawyering. And nothing he's doing is wrong. This is trial strategy 101. And sometimes every lawyer's different. Sometimes it's very congenial, it's very friendly. Other times it can be junkyard dog. I think Rusty Hardin is doing a very good job of showing the elder statesman control of the room and being that voice of reason, and then, having a little bite to his bark every once in a while.
Every once in a while. Yeah, just to don't forget.
Yeah, don't forget who I am. I don't have this name for nothing.
Okay, kid.
Right, exactly. Yeah.
And also, I think, Ryan Bangert showed his chops too. Mm-hmm. One point when they're talking about this foreclosure order, and there's some discussion about this whole thing about settlement services and Paxton, and they also brings up, Ken Paxton had previously done real estate law, and he asked him about that, and Oso says, that's your opinion, sir, and Bangert replies, no, that's the law.
That's the law.
I mean, it was like, whoa.
Yeah, I thought both Bangert and Oso scored points after lunch. I thought Oso's pre-lunch cross was pretty flat.
I agree.
Like you talked about, you think maybe he got a little locker room pep talk because he came out and he was firing. I think Oso did a good job in that cross of getting under Ryan Bangert's skin
Which part would you say?
Well, especially in that whole exchange where it was a yes or no question, and he asks it 20 times, and Dan Patrick is on Oso's side telling him answer, and he just wouldn't answer.
He would not answer it yes or no.
That was the
and never
one,
did.
Yeah, and that was the one time where I felt like he might have stepped out of bounds there and looked a little petulant himself. And kudos to Oso for drawing him into that. I would have, if I was the lawyer on, calling that witness, I would have been sitting there thinking, oh, please, just say yes. It's a minor point, just say yes. The more you struggle, the more you make this into something
It was
it's not.
almost like Bangert never wanted to say the word yes.
Right. Bangert really didn't, and Oso goaded him into that. And I feel like that was the one mistake Bangert made in his testimony. I think overall he was extremely effective.
And he recovered himself.
He recovered
after
well.
That.
He recovered well.
It was as if he realized,
Yeah.
and pulled back into that total professional demeanor that he had been maintaining.
But I don't want to be unprofessional or not unfair to Oso. We're talking about the elder statesman, Rusty Hardin, kind of giving a master class and making jokes about Rusty Hardin is treating Oso like he's some whippersnapper. Oso scored a good point there, and I thought that was effective and it worked.
But given the totality of Bangert's testimony,
that's right. I think Bangert's testimony was extremely
it's
effective.
Like
I don't think it erases
did you
it.
win? You won a point, but did you win the match?
Right. Exactly.
Right.
Exactly.
And Oso clearly did not.
No, I don't think so. Not with that witness for sure.
Right.
And usually who is cross-examining witnesses is thought out well in advance. So I don't think it means anything that another lawyer is crossing the next witness. But it might not be an accident. Maybe they felt like Oso wasn't scoring.
We may get some sense of that if it's a different attorney every time doing the cross.
Right. Because we can't know. It's so easy. I've heard this in my trials. It's so easy for outsiders to think this means this and that means that, and then you find out when you actually talk to the lawyers, I was obsessed with this one fact and it had nothing to do with anything. It could mean nothing.
I have covered, you and I sat together, Mike, and every time I think I know this is what's going to happen, I'm never right.
Right.
Because you never really know what people are keying in on.
No.
What they think's important, especially, and this is most certainly not your typical jury.
Right.
One thing though that in trials often happens is they tee something up because they're going to come back to it later. And maybe that has happened, but I have not seen much of that in this one.
I haven't seen it either.
They've teed things up, but then it's like it just kind of fell off the table after a while.
I wanted Oso to come back to, okay, you think he's so corrupt, but yet your group that you now work for is taking cases to the Attorney General's office.
Yeah.
I wanted...
That would have really been a good point.
I really wanted him to just take the knife and dig it in.
And I was waiting for that, and he didn't do it.
It's like he started it. He started to go down the path, and then he said, go on to the next thing. And I was like, no, that's a good point.
Yeah.
If you think this office is so corrupt, you think it's led by this corrupt person.
Why did your own organization?
Right. Why are you not? Why are you not? Drawing that point out. Now, maybe you wouldn't like the answer, but it seemed like a pretty good point to be making.
Yeah, and a good, again, like we talked earlier about, one of the rules of cross-examination is to establish control, establish pace, and if you do that, then the answer almost doesn't matter. If the entire jury is looking at me because you're essentially just giving yeses and nos and that's all, and the story is coming from me, I don't care if you say yes or no, frankly, and so where Oso has not done well with that is he's not to yes and no's. But so I would.
Well, and even when he's tried, Bangert's just
dug in.
Yeah, and I made that comment. He should have. I talked about it at lunch. He should have punished the witness for not giving him yes and no's early. He did it very well there. We just talked about that. That was the one point he scored. Had he done that in the beginning, Bangert's testimony might have been very different. If you teach a witness every time you do this, I'm going to make you look foolish, and the judge is going to admonish you, they put their tail between their legs a little bit. But once you you let them embolden themselves, and they figure out the judge isn't stopping me from doing this. I'm in control. Once the witness thinks they're in control, that's a problem.
Well, and I think we saw that with Busby yesterday.
Yeah.
I mean,
We saw the flip yesterday.
Right, yeah. But
Yeah.
Busby was in control.
right.
That's right.
I mean,
Yeah.
that was, and he knew it from the second he opened his mouth.
Yeah.
Yeah.
It seems like that Dan Patrick, one, has gotten his sea legs to some extent. So his rulings are a little better
Right.
Yep.
overall. But also, I think it felt, I can't get into Dan Patrick's mind, but it felt like he got annoyed with Oso.
He did.
Yes.
But then interestingly, after lunch, and judges are human beings too. Sometimes they feel
Really?
like, I know.
I know a few
News,
judges.
yeah. So, I mean, sometimes judges worry I'm giving too many calls, or maybe it looks like I'm giving too many calls to one side, and so they start to kind of give
Come
a
to
few
the
the
middle,
other
yeah.
way. Or maybe it was just Oso was doing a better job, but I noticed after lunch, between lunch and
They're
now,
much more sustained.
right, he's getting a lot of his objections sustained, and of course then the other lawyer came in, and I think the other lawyer's doing maybe a little better job with his objections, and that's why he got most of his sustained.
The
But
other guy's
they're-
not coming across as petulant.
Right, but their sustained rate was through the roof compared to before. I mean,
Right.
they
Yeah.
were 10%.
Oh, the
sustained
difference in
prior to
approach
lunch.
between this current this current attorney whose name I
did not
don't
catch his
catch
name.
it.
I haven't
I'm
caught it.
sorry,
Anybody out there
I don't
on
have
YouTube
his
happen
name.
to catch that guy's name? I didn't catch it.
He seems just very businesslike. Just very. This is it. That's what I need, Judge.
Yeah.
And Patrick responds to that. He doesn't respond to eye rolling or big size or
Most judges
Yeah.
don't. In my
Well,
experience.
and
It doesn't work well.
And Dan Patrick's deals with all the personalities in that Senate
There's
chamber.
a lot of personality in that chamber.
Yeah,
yeah.
exactly. Oh, yeah. I mean,
Right.
a lot
He's
of
used to a lot.
personalities.
Yeah.
So,
yeah. And again, as a trial lawyer, there's no one right style. I was watching some of the comments, and people are expecting witnesses to be destroyed, or the lawyer's not doing well because he's not being dramatic. Some lawyers can destroy you as just as soft and quiet and unassuming as possible, and other lawyers come out super aggressive and they're completely ineffective, and vice versa, right? So the main thing for a lawyer is to know who you are and be yourself. And if you're a big showman, be a big showman. If you're understated, be understated. And so, at the same time, you have to, a good lawyer knows how to nudge themselves. I'm not going to become Rusty Hardin, or I'm not going to become, Busby, but if I recognize that something is working better with this judge or this jury, then I'm going to nudge myself that way. And I feel like this lawyer that's just started for the defense is doing a good job of that.
A manila envelope that was maybe a 1/4 inch or less in thickness.
All right, and was it actually contained in a manila envelope?
Yes.
So have a seal, not a seal, but like a little closing up at the top?
A label.
All right. Did you keep it sealed, or is it just in a manila envelope?
It's just in an envelope, not with the flap on top, but just a folding manila envelope.
I got you. All right. Now, at this time, we are, I think you said somewhere around May 28th, is that right, when the file you're estimating was brought back to you?
Yes, sir.
And that would have meant when you said that you believed you gave it to him around when in May?
The middle of May.
So about, the math would say like 13, 14 days. But you give me what your figure is.
I would say May 23rd.
May 23rd when you gave it to him?
Correct.
All right.
And then when it was returned on the 28th.
I got you. So you didn't have it for about 5 days.
7 to 10 days was what I recall. I apologize for the math.
All right. So at any rate, that period of time, it was out of your possession to be in the possession of the Attorney General, correct?
Yes, sir.
All right. Now, when you got it back, so let's say toward the end of May, what was the next event or conversation you had with anybody, the Attorney General, concerning Mr. Paul?
The last meeting that we had regarding the Department of Public Safety file was that we did not recommend changing our conclusion to protect the information, but that there might be an alternative solution to take in issuing a ruling.
Why did you come up with an alternative?
General Paxton had asked us to find a way to release the information.
So who came up with a possible alternative?
Justin Gordon, who's the chief of the Open Records Division, had...
And what was that partial, that compromised position?
It was basically taking a position of no position. So we were not making a ruling saying to withhold the information, and we were not making a ruling to release the information.
Had you ever participated in that kind of position before?
No, sir.
Were you aware of it having been done before?
Not until Mr. Gordon suggested it.
Now, I'm not suggesting to you that never had it before happened in my question in the AG's office. I really am just simply asking, were you familiar with it ever having happened before?
No, not in the open records context.
All right. Now, well, what would be the implications of taking a position of no position? Would that be of any advantage to anyone as opposed to declining to release it? Let's do this. Under no position, would there have been 3 possibilities then that you would be treating that request? Here's what I mean. Just a flat out, we're not going to release the information because of law enforcement. That would be one, would it not?
Yes.
Another would be release the information, give it to them as they request. That'd be one, right?
Yes.
And then in the middle of that would be take no position, correct?
That's right.
If you take no position, does that have any different consequences than refusing to turn it over?
Objection. Mr. President, calls for speculation on the witness's part.
Sustained.
All I'm really asking you, I want to try to ask you in a way that's acceptable. I'm trying to determine what is this, why do no position then as opposed to just you can't have it? What's the significance of no position?
General Paxton didn't want for it to appear that his office was aiding the Department of Public Safety or the FBI. And so by taking a position of no position, it was semantics, I suppose.
Well, what is your testimony as to whether if you say no position in terms of what you're communicating to people outside the agency as to the level of resistance you have to resisting?
Objection. Mr. President, calls for speculation on the witness's part.
Sustained.
Now, at any rate, was that the decision that was made?
Yes.
No position.
We were directed to take a position of no position.
And in these conversations and all with the Attorney General,
Yes.
had you expressed your position in being opposed to that?
Yes.
Had Mr. Bangert expressed his position of being opposed?
Yes.
Was there anybody else involved in talking about it with the Attorney General?
Not with the exception of Mr. Gordon, who had attended one of the series of meetings.
All right. And was Mr. Gordon have the same position as y'all did, even though he's the one who came up with no position?
Yes, my recollection is his initial review was very flattering of the quality and the content in the FBI's letter ruling.
Now, after that, did there become a separate issue from reviewing the file? At some time, did Mr. Paxton's lawyer's position, Mr. Paul's lawyer's position become, well, we want the unredacted FBI brief?
Objection, leading and compound.
Well, I'll be glad to rephrase that. Let me give it if that's okay.
I'll sustain it and rephrase.
Thank you very much. So let's go back now. And in that file, was there a brief that had been prepared by the FBI saying why the documents should not be released to Mr. Paul?
Objection, Mr. President, asked and answered.
Overruled.
Was there?
Yes, there was.
And you got to speak in the microphone. Is your microphone on?
Yes.
Okay.
Yes, there was.
That's all right. And you're going to find you get tireder and tireder as the day goes on. You got to stay up there. I speak from experience, okay? In this particular case, did the FBI brief, what type of information was in the FBI brief if it was not redacted?
Objection, Mr. President. This calls for hearsay and the contents of a document that is not in evidence.
There's no hearsay at all here. This is simply asking what documents are. These are not communications. This is nothing.
Hold on 1 second. Overruled.
What type of documents were in there?
The FBI's
I say in there, referred to in the FBI brief.
Right. The FBI's brief identified emails, text messages, strategic planning, staging locations for the raid in August of 2019. They identified the task force members. The brief identified a under seal probable cause affidavit that said it was filed under seal, and the FBI brief indicated that that seal had not been lifted.
And so, including all these, when we talk about that affidavit sealed, it was actually under seal at that time in a federal court, wasn't it?
That's what the FBI brief
So
said.
the federal judge has ordered it sealed. It had not been unsealed. But if the FBI brief unredacted was released to the object of the investigation, that person would have all kinds of information that a federal judge had sealed, correct?
Objection, Mr. President. Leading.
I'm asking just, is that correct?
Sustain, rephrase.
What type of information, without going into the details of the FBI, let me back up this way. In the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background and history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against this disclosure?
Objection, Mr. President. Once again, this is not, the witness's testimony is not the best evidence of the content of this material. Well, has not been entered into evidence, and it remains hearsay.
Your Honor, surely we can't keep that information from this record. I'm asking him simply of the types of information that was in there.
We'll overrule. You can ask for the types of information.
Thank you.
Limited to that.
So, I believe my question was, in the FBI brief, did they, without saying right now what they were saying, did they lay out sources, names of witnesses, background, history of the investigation, personal data of investigating officers, and personal data on individuals? Was that included in the FBI brief as they argued against this disclosure?
Yes, that was all the content of the probable cause affidavit that I recall.
So, what was your understanding as to whether or not lawyers for Mr. Paul were asking for things to be disclosed by the Attorney General's office that a federal judge had refused to disclose and sealed?
Objection, Mr. President. Leading.
I can ask it another way. Were you aware that a federal judge had placed these documents under seal?
Yes, sir. Based on the content of the FBI brief that indicated that the records were sealed and that the probable cause affidavit was identified as sealed.
So essentially, was the Attorney General of the state of Texas seeking to reveal to a person under a federal investigation the basis of the evidence so far that the government had against him?
Objection. Leading.
Sustained, can you rephrase that?
Sure. Was there a clear clash here between what the judicial system had decided somebody that it should be sealed versus a man under investigation seeking the sealed information?
Yes, that was my opinion.
And was the information he was seeking particularly harmful and dangerous to other people, if disclosed?
I believe so, to the extent it revealed the law enforcement information within the probable cause affidavit, the investigators that were involved, and other government officials that participated in the decision.
All right, so how did it proceed now about whether or not, by the way, by this time, can you give us a time frame where all of a sudden they're seeking the FBI brief?
I believe the request was submitted May 24th of 2020. So it was in the middle of our conversations about the DPS file itself.
All right, and did they, when they were seeking it, how long do you think it was before y'all provided an answer?
I think the answer was due sometime in July. I want to say that July 28th.
Of their open records request for the FBI brief, is that what you mean?
Correct.
Okay.
So if I can lay it out,
yeah, please,
on a calendar.
Please.
The DPS file was due June 2nd. The request by Nate Paul's lawyers to the AG's office for the FBI brief was received May 24th. I believe the deadline to issue that ruling was July 28th, just based on the 45-day or 55-day time period.
Mr. Vassar, if we do this in a time frame, what is your testimony as to whether or not the request for the FBI brief by itself came before the no decision on the release of the DPS file? Did it become before or after?
It came before, because the DPS decision was not issued until June 2nd.
All right. When the June 2nd position was issued, I believe that was what you said was the no decision, is that right?
Correct.
All right. Now, anytime after y'all said no decision, was there any attempt anymore by people on that Mr. Paul's position, excuse me, was there any attempt any longer to get access to the whole file?
No, not to my knowledge. So just generically, under the Open Records Act, when the Office of the Attorney General makes a ruling, the parties have the right to appeal that ruling to the district court. I'm not aware if that happened.
That's another way. So to your knowledge, are you familiar whether or not after y'all said no to the DPS file on June 2nd, was there any attempt by Mr. Paul's lawyers to appeal that to a district court as they were entitled to?
I'm not advised of that.
And instead, did they move to be trying to get an unredacted version of the FBI brief?
It's the timelines are suspicious.
And they're suspicious for what reason?
Sorry, Mr. President, I'm going to object to the witness's speculation and unresponsive statement and ask Your Honor to strike it from the record.
Yeah, we'll sustain that and strike that from the record. You can ask any other question.
When you issued no opinion on June 2nd, was there in that no opinion a redacted version of the FBI brief?
No, sir.
All right. As of June 2nd, had they had access to the FBI brief with the probable cause affidavit setting out the basis for the search and arrest?
Objection.
Just give me just a second, I'm sorry.
Please.
Strike the word arrest. There wasn't an arrest. I didn't mean that. Go ahead.
Objection, Mr. President. Calls for speculation. I understand the question to be asking for what Nate Paul's lawyers did or didn't have, unless I misunderstood Mr. Hardin.
Objection sustained.
Would it change if I said he misunderstood me?
Give it a try.
All right, no problem. All right, now, let's do this. What was the decision? Did you have any conversations with the Attorney General on the issue of releasing to Mr. Paul the FBI brief?
Yes.
How did those conversations happen? When? Where?
They coincided with our conversations about the DPS file, just given that the timelines overlapped.
All right, so can you estimate the time frame when you talked to the AG about whether to release the FBI brief?
I believe it was the last week of May.
And when you did so, what did you do? I mean, what was the decision? Can you tell me what the Attorney General said?
I had notified General Paxton that the office had received a public information request related to the DPS file, and it was a request for the unredacted FBI brief that the FBI had submitted.
And what was his response?
He asked to see a copy of the two briefs, the redacted version and the unredacted version.
Did you give them to him?
Yes.
What happened next?
We met maybe the next day, and he showed me the two versions that I had sent to him, and he had highlighted and circled and marked up some of the documents. And he stated to me that he didn't see anything in here that should be withheld.
Attorney General of the state of Texas, are you saying, actually went over the affidavit and the brief, all the information that was referred to in the brief, and made circles himself on it?
He marked up the copies of the letter brief that the FBI had submitted to the Office of the Attorney General.
And the Attorney General decided, what had been your advice as to whether it should be released?
Well, the initial step in that process would have been to notify the FBI that the office had received a request for its information.
Did you do that?
Yes, I did not personally, but...
Was it done?
Yes, sir, it was done.
And what was the status? Were you waiting for their response?
Yes.
What was did the Attorney General have a position about that?
On the response?
Yes.
So it was my understanding that there was a delay in either connecting with the FBI or the correct person to make a decision on whether to respond and how to respond. After a follow-up attempt to contact their office, I don't know the content of that conversation, but I know we made a couple of attempts to contact them.
And then when you were unsuccessful in figuring out who in the FBI to talk to, what happened then?
After mentioning all of these sequences of events to General Paxton, he directed us to let the brief go out.
And he had earlier told you he didn't see anything that was a problem releasing?
That's right.
Do you know anything about the criminal law or practice history that Attorney General might have been particularly informed about to make those kind of decisions?
Objection. Mr. President, calls for speculation.
No, let me rephrase it to make sure it's understood.
Sustained.
Do you know of anything that you've ever witnessed or observed in terms of knowledge, background, or history of the Attorney General to be making a decision about what law enforcement information should and should not be released?
No, sir.
All right. Now, when you released, are you saying that the Attorney General's office released an FBI brief, unredacted, to the subject of a federal investigation, in spite of it having pointed out that the information in there currently was under seal with the federal judge?
Objection, Mr. President, leading.
I don't think that's leading. I can...
Sustained.
Pardon me?
Sustained.
All right.
Rephrase.
Tell us exactly what the consequences and what he did when he ordered that brief to be released to the subject of a federal investigation?
So the decision to release the information was done under the Public Information Act in order to reach a decision that the office was required to make in response to a request for information. Based on what I recall, the absence of the third party responding or responding in time or informing the office that it didn't intend to fight the release resulted in a release under the act.
Well, would you have released it even if you were making the decision? Let me put it this way. You, as a courtesy, tell fellow law enforcement agencies this is under consideration, correct?
It's a required notice under the Public Information Act.
In your processes, are you allowed and able to review law enforcement information from another agency? And even if you don't hear from that agency one way or the other, do you have the authority to declare the law enforcement exception to apply and hold it back even if you don't hear from the other agency?
There are situations in the open records context when the Open Records Division may raise exceptions based on the information that it reviews that may not have been raised by the parties.
In this particular case, what was your position, even when you had not heard from the FBI yet? What was your position as to whether this FBI brief, unredacted, should be released to the subject of the investigation?
I believe that it should have been withheld just based on the content of the document.
And did you argue that position?
Yes.
Did you argue that position even when you had not heard yet from the FBI?
Yes.
And once that information is it released under any conditions, or can the recipient share it with anybody he wants to?
It's not released under any conditions.
So when you release law enforcement information through a Freedom of Information Act or public records request, once that information is out, if anybody wants to find out, what would be the possibility if anybody with larceny in their heart wants to know addresses, names, all kinds of personal information about law enforcement or witnesses? Would they potentially have access to it if the possessor wants to give it to them?
Objection, Mr. President. This is leading and calls for speculation on Mr. Vassar's part.
Sustained.
Mr. Vassar, are you aware that in September of 2020, a, quote, special prosecutor was serving subpoenas using the names and addresses of officials that appeared in the file that your agency released?
Objection, Mr. President.
Are you aware of that?
I'm sorry. Objection, Mr. President.
That is why this is relevant.
Don't talk to each other.
Second.
What is your objection?
Objection. Assumes facts not established in evidence in this trial, Your Honor.
Your Honor, I swear to you under my oath as a lawyer, you're going to have that evidence presented. Now,
I don't have it now.
Pardon me?
We don't have it now.
I know that, but it's coming. My point being is I'm only asking him if he was aware the event happened. When he talks about evidence not be before the court as yet, I'm seeking to find out if he's aware how this information was used. He can say he's not aware, and that ends the inquiry. But if he says he does, it points out the danger of what exactly happened here in this case, which is at the heart of the major impeachment contentions that we have.
Mr. President, may I be heard?
Yes.
I have great esteem for my colleague. However, I promise it's coming is not a proper response to that objection.
Sustained.
I'll have this question. Was the type of information I talked to you about available then to the recipient once you released the FBI brief?
Mr. President, same objection, same horse, different question.
Still a legitimate question. The question was that available to the recipient? That's all. I haven't asked about anybody else you haven't heard information about. I'm talking about the person in this case, Nate Paul.
In this case, Counselor, I'll overrule.
Was it?
The information that would have been in the FBI brief is what would have been disclosed to the requester.
Thank you. Now, can I move on to, was that the last contact? To your knowledge, did the representatives of Nate Paul make any more attempt after you released the FBI brief? Was there any more attempt to get the information from the DPS?
Not to my knowledge.
So what is your testimony as to whether or not, after you issued no opinion, but then released the FBI brief, was there any more attempt to try to get to a fuller file of DPS?
Not to my knowledge.
Thank you. And was there any lawsuit, to your knowledge, filed in state court to try to get it?
No, sir.
What did that indicate to you?
They may have gotten the information.
From some other way?
Yes, sir.
All right. Now, if we can, when's the next thing you had to do with Mr. Nate Paul?
Well, unknown to me at the time, Ryan Banger contacted me on July 31st, which I think was a Friday, in the evening, and asked me about a foreclosure opinion.
Did you, and how did that come about? That was, but you remember what day of the week that was?
It was a Friday evening.
All right. And Mr. Vassar, what did you understand that your responsibilities and mission were?
So Mr. Banger contacted me and told me that we needed to look into foreclosure sales.
And did you understand, who did you understand this was a request from, that you were asked to do this?
From General Paxton.
Do you recall where you were when you got the information?
I was at home.
And what did you do as a result?
I responded to Mr. Banger over the phone and told him that I would look into it. I would give him a first draft as soon as I could.
Now, what time of day was it? First of all, what day of the week was it?
Friday.
And what time was it on Friday night that Mr. Banger called you?
Between 5 and 7. I mean, it was.
And at that time, did you understand in response to the initial call there was any urgency one way or the other?
Yes, it was.
And when were you supposed to try to have this opinion?
As soon as possible.
What did that mean to you? No, it's okay. Go ahead.
I told Ryan that I would get him a draft sometime that evening, if not first thing in the morning.
All right, did you do that?
Yes.
And then what did you do the rest of the morning in connection with it?
Ryan and I spoke about the draft. He agreed with the initial conclusion, which decided that foreclosure sales should be allowed to proceed under the governor's executive order at the time.
All right, and were the two of you in agreement with that?
Yes.
About what time of day did y'all get a document that you thought was sufficient to send over to the Attorney General as a draft?
It was probably 11 to 12 on Saturday, that next day.
What's the next thing you did in connection with it?
Ryan called me not long after that, probably 30 to 45 minutes after he had sent it to General Paxton.
Were you aware as a result of that phone call whether he had talked to the Attorney General?
Yes.
And as a result, what did you understand your new mission was?
I understood that General Paxton said that we got the wrong answer.
All right. So the right answer had been what, in your view?
Well, based on the office's position on numerous COVID-related matters, we had erred on the side of opening Texas, not closing Texas or prohibiting people from gathering. We had issued a number of opinions relating to houses of worship, election issues, and schools, all of them encouraging opening, not closing it. So the initial conclusion was based on my understanding of the office's position throughout the summer.
And did you make a legal determination that that went in line with what you believe the office policy was?
Yes.
And then what happened when you were told you had the wrong answer? What did you do?
I laughed.
Why did you laugh?
I just because I found out that I had gotten the wrong answer when I believed I had reached the right answer just based on the office's position throughout the summer.
All right, so then what did y'all do?
I told Ryan that I would take a look at reaching a different conclusion. I think he volunteered to do that and made modifications to the draft that I had sent him.
Now, you two guys are deputy chiefs of the whole office, right?
Ryan at the time was deputy first assistant, and I was deputy for legal counsel. Yes, sir.
Well, you were pretty high up in the food chain, were you not?
Yes, sir.
How often do you two write opinions?
Rarely.
Do you have any idea why the two of y'all were doing it rather than very capable lawyers underneath you in the litigation section?
I think it was a priority issue that General Paxton wanted someone to get it done as quickly as possible.
All right, so who did the main drafting this second time?
It was essentially the same shell of the first draft, and Ryan Banger revised the conclusion to conclude that foreclosure sales should not proceed.
Were you aware of at that time any contacts that Mr. Banger and the Attorney General were having in drafting the opinion?
I knew that Ryan Banger was speaking with General Paxton.
And were you getting any kind of progress request or not? Were you aware of how often they were speaking one way or the other?
No.
All right. And then was there any challenge to rewrite it?
Well, I mean, we had to go back and adjust the analysis to the extent we could based on the position that we had taken initially.
All right. Now, once you completed it, about what time in the morning on Sunday did you complete it?
I spoke with Ryan throughout the day on Saturday after we were exchanging drafts and trying to reach an opposite conclusion. It's my understanding that he finished around midnight on Saturday evening.
But was he passing on to you, y'all discussing at that time any involvement in the Attorney General in the editing process?
I was not involved in any conversations directly.
That was going to be my next question. So during that entire evening that night, is it correct to say you were not dealing with the Attorney General, only Ryan was?
That's right.
Okay. Now, once it was produced, at any time during that process, did you have any idea whether or not this was something that would or would not benefit Nate Paul?
No, sir.
Did you later change your opinion or your sense of awareness?
Objection, Mr. President. This calls for speculation.
I'm only asking about his mind state. I'm not asking anybody.
Overruled.
Thank you. Go ahead.
Yes, sir. I believe Monday, I think it was Tuesday.
And what changed your mind Tuesday?
Well, foreclosure sales across the state are held on the first Tuesday of each month. So when the opinion was announced on our website on Sunday at roughly 1 in the morning, a foreclosure sale was reported in the media to have been...
Objection, Mr. President. Any reports in the media would be obvious hearsay and inadmissible.
Sustained.
All right. All I'm going to ask you is, did news reports provide you information that changed your sense of awareness?
Same objection.
I'm not asking you what you heard, not asking you what you read, not asking you any hearsay or anything. Just simply, did news reports later change your sense of awareness, whatever that was?
He's just, excuse me, he's just asking about did it, not what was in them. Overruled.
Yes.
All right. Now, at the end of the day, did whatever that opinion was, did that concern you, and if so, why?
Well, not at the time. It was odd, but it wasn't concerning because at the time I had no context for who was involved or what it was for.
And then once you did have a context about who might be involved, did that change? What was your reaction to that?
It was even stranger that we would have gone through that effort to become involved in a potential Nate Paul related issue involving foreclosure sales.
Okay. Now, after that opinion was done, did you have anything else to do with anything that Mr. Nate Paul and his businesses did, whether it was later bankruptcy or any other events? Did you know anything else? Do you have anything else to do on that front, on foreclosure front, with Mr. Nate Paul or his affairs?
No, sir.
All right. Now, let's go to the final area I want to talk to you about. Was it tell us what your responsibilities were if somebody above you or below you wants to do a contract with an outside lawyer. Let's start here. What was the policy generally of getting outside law firms within the agency? How would that happen ordinarily?
So ordinarily, with an agency of 800 lawyers and 4,000 employees, there are sometimes a need to retain outside counsel. That could be because it's a specialized area of law. Maybe it's intellectual property law, where the Office of the Attorney General doesn't employ IP lawyers. It could also be a local counsel issue. If the state of Texas wants to intervene in a Virginia case, the office would need local counsel. So there are unique instances where we would have engaged outside counsel to represent the agency. All of those requests are managed by the General Counsel Division, which I oversaw in my role as Deputy Attorney General for Legal Counsel.
Well, now, how often in your memory have you ever recall outside counsel being retained to do a criminal investigation?
None.
Ever?
No, sir.
All right, and why is that?
Mostly just because the prosecutors and the attorneys in the office would handle that work.
So when did you first become aware that the Attorney General wanted to hire an outside law firm for a criminal investigation regarding the complaints of Nate Paul?
Well, the first time that General Paxton contacted me, I believe, was in the middle of August of 2020.
And what was the nature of that contact?
He wanted to know what the basic process was to retain outside counsel.
What did you tell him?
I told him exactly what I just explained to this chamber of there has to be a request, there has to be a specific need. The attorneys have to be vetted to ensure that there's no potential conflicts of interest. And there's a formal approval memorandum and a outside counsel contract template that is signed by the attorney and the Office of the Attorney General.
So can we have our exhibit 160, please, Stacy? Is that not in evidence? All right, we moved into evidence 160. Thank you.
No objection at all, Mr. President.
Show 160 be admitted into evidence.
Now, I'll represent, well, you tell me, what is exhibit, do you have a hard copy?
It's on the screen right now.
Okay. Do you recognize what it is?
I do. It's an email from myself to General Paxton's Proton Mail email address dated September 3rd of 2020.
Now, that's a different type of email address than the official Attorney General email route, isn't it, or is it? What is a Proton address?
I'm not sure. I believe it's a private email service.
Well, it's been suggested by his lawyers that that's very frequently used in your organization. Is that true? And there's a Proton email address in addition to your official one, very commonly used with the people in the office.
Objection, Mr. President, lack of foundation and calls for speculation by Mr. Bassett.
No. They can't do what they did. You heard the cross-examination in this kid talking about how common and ordinary it was and everything. Surely I'm allowed to ask this witness if that's true.
Mr. President,
That's all I'm doing.
I'm sorry, Mr. President, I believe we've invoked the rule and perhaps should not be talking about what other witnesses testified to with this witness.
I was getting ready to say that.
Pardon me?
I was getting ready to say that.
Yes.
Sustained, and you should not be talking about other testimony given in that specific instant.
Well, let me ask you. If one were to contend it is commonly used within your agency to have a Proton email address, would that be accurate or inaccurate?
Objection, Mr. President, calls for speculation.
Your Honor, this is really...
Yeah, overruled. Go ahead.
Thank you.
Not to my knowledge. I've
Pardon me?
never, not to my knowledge. It would not be ordinary to me. I am not even sure what it was.
Yes, I'm not trying to suggest it's never done, but in your experience, have you frequently or infrequently been dealing with official business in your agency with the Proton email address?
Objection, relevance.
I asked whether he...
Overruled.
Yeah, thank you. Go ahead.
No, sir.
All right.
This could be the first time that I had used that email address for General Paxton before I hadn't seen it before.
How did you know to use it here?
I think I asked him for his email address that he wanted me to send the contract to, the draft.
The general himself?
Yes, sir.
So are you saying that 5 years you've been there, this email address is the first time you ever used it in dealing with him?
Objection, leading.
I'm asking, just try to be clear.
Saying the objection, but rephrase.
Thank you. In this particular case, do you recall when he gave you this, how did he ask you to do it, first of all? Did he call you, drop in on you, or how did this happen?
The first time was a phone call when he asked about the basic process for retaining outside counsel. The second, he came into my office on September 3rd, and he instructed me to draft a contract for Brandon Kamek.
And then did he tell you at that occasion where to send it?
Possibly. If I didn't follow up with him to ask him, he could have instructed me in my office on that day of where to send it.
Ordinarily, if you sent it to his regular official agency email address, who would have access to it?
I believe the assistant has access to his email box. I don't know if he had access.
Would this Proton address be on access? Would other people be? Is there any way other people would be aware of it or ultimately run into it? If you sent something at this address, does that become available to others, or would it be only to the user of this email?
Objection, Mr. President.
If you know.
Calls for speculation, lack of foundation, assumes facts not in evidence.
I'm not asking for any. I don't know what facts are not in evidence I have talked about. I simply trying to find out is if this is used, would that then be restricted in availability to the Attorney General? That's all I'm asking.
And Mr. President, what I will renew is my objection that there is no foundation laid for Mr. Vassar to know anything about what the other agency employees can access or cannot access.
Sustained.
Now, when you sent him this contract, did you draft anything in there that was a little different?
Well, I drafted the scope of work.
And when the Attorney General asked you to do the draft, was anybody else around you when he asked you to send it?
No, sir.
Did he describe to you what he wanted this person to get a contract for?
Yes.
What did he tell you?
It was my understanding that Mr. Kamek was being hired as a second set of eyes, if you will, to review the Travis County District Attorney's referral of the complaint involving Nate Paul.
And had you been ever asked to do that in the criminal law area before?
No, sir.
When was the last time you had done an outside agency contract for somebody to do a criminal investigation?
I can't recall one.
Does that mean you don't remember any?
That's right.
All right. So when you did that, did you pay attention to a particular concern as to how to limit the scope of work?
Yes, sir.
Why did you do that?
Well, the referral from Travis County used specific language about providing assistance to Travis County.
Did you look at it at the time, the referral?
The first time I was given a copy of the referral from Travis County was September 3rd.
Were you aware at that time, one way or the other, of any conversations and disagreements that had been occurring internally as to whether Mr. Kamek should be hired to do this? Were you aware through talking to other people or any other source?
Objection, Mr. President. That response would call for hearsay.
I've not asked for the statements yet. I've asked if he's aware of anything.
I'm going to sustain. Would you re-ask the question?
Thank you. So, at that time, were you aware of any other concern about this matter, namely Mr. Kamek being hired to review a criminal investigation or whatever the assignment was? Were you aware one way or the other as to whether there was any opposition by other people in the organization to hiring Mr. Kamek for this project?
Objection, Mr. President. That would be derivative of hearsay.
I have asked simply whether he's aware of...
Overruled.
Thank you.
He can answer.
Are you?
Yes, sir.
Is that another reason you wanted to be cautious?
Objection, leading.
All right, that's fair enough.
Sustained.
Are you? Thank you, Judge. Were you, because without going into what you said, had you had conversations before September 3rd with the Attorney General about this matter?
Yes, sir.
When did you have your first conversation with him about it?
The first time would have been when he asked about the basic process. That would have been around August 15th.
And at that time, did he talk to you at all about what he had in mind?
No, sir. It wasn't until the week of August 26th, I believe, when I was on vacation, General Paxton called me and asked me to explain the process, the basic process, to two individuals.
Did he mention Mr. Kamek's name?
Yes.
What did he say to you?
He just asked me to contact both of the individuals, explain the process to them, and that these were the two individuals that...
The other person, why two individuals? Was there somebody else under consideration?
There were two names that General Paxton gave me.
And what was the other name he asked you to prepare a potential contract for?
Joe Brown.
All right. Mr. Joe Brown had been a previous U.S. attorney, had he not?
Yes, sir.
All right. Now, so did you prepare a contract like we just introduced for both Mr. Kamek and Joe Brown?
No, sir.
All right. Whom did you prepare the contract for exclusively?
So the only contract that was prepared in this matter was for Brandon Kamek.
And why did you not do one for Mr. Brown?
Based on when the Attorney General came into my office on September 3rd and directed me to prepare a contract for Brandon Kamek, it was my understanding that there was no longer any need for a contract for Mr. Brown.
All right. I want to take the contract now. Stacy, if you could put up, I moved to introduce 160. I'm not sure I got a reaction one way or the other.
Mr. Hardin, you admitted it.
Thank you.
Yes.
Yeah, it's admitted.
Thank you, Your Honor. I want to move on this contract of September 3rd over to the addendum. Can you go to the next to last page, which says Addendum A? You have that?
Yes, sir.
And is there a portion of this contract and this addendum that you can direct the court and the jury to that will show how you tried to restrict the scope of activity in this contract?
Well, and again, this was all drafted based on my understanding of General Paxton's decision of what Mr. Kamek should be doing, as well as the conversations about the Travis County referral and the extent to which it authorized our office to assist. You can see that the first paragraph specifically refers to certain criminal violations made by state and federal employees. So there's a singular referral that this contract is referring to.
It says, does it not, that this is to be a review of the allegations, correct?
That's correct.
One could review the allegations just by looking at them, right?
That's right.
Object to the sidebar. Move to strike.
It's not a sidebar, it's a question, Your Honor.
You can strike the word right.
Okay. And a review of the allegations, which include complaints of potential criminal violations made by certain state and federal employees. Were you aware at that time of any of the details of what was in Mr. Paul's complaint?
When I drafted this scope, that was the first time that I received a copy of the referral and a copy of the complaint.
And when you looked in the referral, when you looked at the documents that Mr. Paul had provided the Travis County DA's office and that they sent over to the Attorney General's office, what type of allegations did you note as to what type of people and conduct this young man was to look into?
Based on what I recall, Mr. Paul had alleged that certain members of the FBI and the task force, the Department of Public Safety, may have taken his phone from him or not allowed him to contact his attorney. They may have damaged property searching through evidence. I don't recall the specific nature of the allegations other than just...
Were there allegations about improper conduct by a federal magistrate?
Yes, sir.
Did that give you pause?
It did.
Well, all right. So when you see these kind of allegations, then how did you draft it to try to take care of that, in your opinion?
Well, the last paragraph refers to conducting an investigation under the authority of the OAG, which would be derivative of the complaint, which is to assist. Towards the end of the paragraph, it explains that notwithstanding anything else, outside counsel should only conduct an investigation consistent with the complaint and only as directed by the Office of the Attorney General, meaning that any activities that he wanted to pursue should have been authorized and approved by the office.
And in it, as the way you structured this, do you make any reference in there to this man becoming a special prosecutor?
There's a plain exception that says that the legal services under this contract do not include any other post-investigation activities, including but not limited to indictment or prosecution.
So, as you believed when you drafted this contract and circulated it to be approved by others, what did you think this contract was setting out, giving him the authority to do if it was approved?
In short, he was to review the allegations in the complaint, the statements in the complaint, prepare a report that would be returned to our investigators to provide a second opinion to General Paxton.
And those investigators of yours would have been of who? Who would they have been turned over to?
David Maxwell and Mark Penley. David Maxwell was the director of law enforcement at the office, and Mark Penley was the Deputy Attorney General for Criminal Justice.
Did you have discussions with the Attorney General that this is what he was authorized to do? Or did you have any, first, did you have any conversations with the Attorney General about this?
Yes.
About this restriction?
About the nature of the services that CAMIC was being hired for, yes, sir.
What did you say to him?
I just explained that we can't, the OAG, the Office of the Attorney General, cannot ordinarily engage in a criminal investigation except for a referral, a case of a referral. General Paxton explained that he had a referral from Travis County, and then I explained that even under a referral, we wouldn't have an outside counsel representing the agency in a prosecutorial role.
What was his reaction?
He didn't have one that I recall.
All right. And so then, after you have done this, what kind of process it was supposed to go? When you sent this to the Attorney General, did you get a response from him?
No, sir.
Did you hear back from him on this?
Not that I recall. When he asked me to send him a draft of the contract, he also asked me to send it to Brandon CAMIC.
Well, so if I can, I move to introduce 161, please.
don't see this on our list. Has this
I'm
been
moving
agreed
to introduce it. I believe it's not in evidence.
Okay.
No objection, Mr. President.
Stella, can I have a hard copy, please?
There are no objections when you receive it, Mr. Harden, you may.
Thank you very
We'll
much.
admit 161 to evidence.
Thank you. Now, this is, would you identify this for me on September the 3rd? Now, this is, I'm sorry, Your Honor, may I have just a second? Mr. Vassar, I want you to look at 161. I want you to look at 161 and see if that is basically the same document that you had sent the same day on September 3rd, except that this one is to Mr. Kamek. Is it the same document?
Yes, sir, that's right.
All right, so now you have forwarded a contract to Mr. Kamek and the same contract to the Attorney General. But what all would be necessary to happen before this became a true contract and Mr. Kamek authorized to work for the Attorney General? What would be necessary?
So ordinarily, when the Office of the Attorney General wants to engage an outside counsel, that has to be approved internally through what was referred to at the time as an executive approval memorandum. That memorandum would explain the background of the request, the nature of the legal authority through which the agency could act, and the amount that was likely to be expended.
All right. In this situation, if you're going to go through the matrix for the contract, would you explain on this type of procedure what would it be the process? How many people would have to approve of this?
I'll run through them very quickly, but generally the process would start with the General Counsel Division Chief. It would next go to the Financial Litigation and Charitable Trust Division. Budget would be next. I believe I would be next in line as the Deputy Attorney General for Legal Counsel. Given the nature of the services involved criminal justice, Mark Penley, the Deputy Attorney General for Criminal Justice, would have been next. I believe Lacey Mays was next.
Well, in y'all's process, what happens if anyone along that chain refuses to accept it or approve it? What happens?
Basically, the request is denied, but it could be revived based on further conversations.
All right. In other words, everything stops if somebody declines until at least it's talked about more? Is that what you mean?
Yes, sir.
All right. So what happens if the Attorney General goes out and unilaterally hires somebody without sending it through the process at all? In your opinion, could he do that?
Yes, sir.
All right. He has the authority, right?
Yes, sir.
He's the guy. Okay. Now, if in fact, are you familiar with why y'all follow those processes, though, that you've just described that would be in the ordinary situation? Why do you do it that way?
Mainly for efficiency purposes, but also just to ensure that each decision is vetted by the divisions that may have input or advice on the specific issue.
So are the people that are put on there division heads of the divisions that are affected by the contract?
Yes, sir.
So in this contract, what all divisions would be affected that would have to okay it?
The General Counsel Division, the Financial Litigation and Charitable Trust Division, the Budget Division, myself, the controller, the agency controller, the deputy for administration, the deputy for criminal justice, the chief of staff, and the first assistant.
It's like 8 people, isn't it?
There's a lot.
Hey, thanks a lot. All right. Now, let me ask you, in the emails that we looked at, or in this document, 161 is a contract. Earlier, some emails when we looked at 160. 160 is the contract that goes to Mr. Paxton. 161 is a contract that goes to Mr. Kamek. Is that correct?
Yes, sir.
And then you go, if you want, 228, contract 228. Contract, exhibit 228. Well, hold that, please. Don't put that, hold on, I'm sorry, Joe. I apologize. I want to ask you I want you to look at 166. I believe this is already in evidence, Your Honor, because I think it's already been up on the screen once.
Yes, it is.
Thank you very much. 161, now I want you to look at this and describe for everyone whether this sets out the approval level it has to be done. Does it?
Yes, sir.
All right. Now, this is the contract that is to be the process to get Mr. Kamek's contract approved, correct?
That's right.
So it starts out with Joshua Godby, the Charitable Trust Division. Why would he have to approve it?
So the Financial Litigation and Charitable Trust Division manage the Office of Attorney General's outside counsel contracts.
Do y'all ever approve a contract that hasn't been the agreement to fund it? Who has to agree to fund it?
The Budget Division has to approve funding.
All right. Let's go up. Then Josh Godby, after him is Ryan Vassar. Who drafted this particular document?
I did.
All right. And how did you know what to put down here under the synopsis and background?
Just based on my understanding, again, of the nature of the services that Kamek was being engaged for.
Excuse me.
Mr. President, I believe there may be some distrust over whether this document is actually in evidence. We do not object to it. It has not been offered.
Yeah, we're just re-looking at that now. So it was not entered, but you do not object. Is that correct? Pardon?
Not.
Okay.
I believe it was shown by an earlier lawyer on your side. I think you had
It was a pre-trial issue that didn't come in.
We're good.
But you're good. Go forward.
Thank you very much.
You did not
Joe.
object.
No, thank you. Thank you very much. Now, let's...
Excuse me, for the record, 166 is admitted to evidence.
Thank you very much. Now, so you prepared over on the second page, or it says page 1, but second when you turn it, the synopsis of what happened in the background and all of that?
Yes, sir.
I want you to tell us in your own words, when you sign off an initial, this particular contract, did you sign off as if you approved it?
Yes.
All right, why did you do that?
I concluded, based just on my position of whether the agency had lawful authority to hire an outside counsel, Brandon Kamek, in this situation, that it did.
So you understood who wanted to hire him?
Yes.
Who was it?
General Paxton.
Describe it in your own words. Did he make clear he was going to do it?
Yes.
So did you have any doubt whether or not that's what he was instructing you to do?
No, sir.
When you draft it, put a synopsis and initial it. Tell us in your own words, what was your position then as to whether this contract should or should not be approved?
So based in my position as Deputy for Legal Counsel, my role was to recommend based on whether the agency had lawful authority to act, not whether it should act. So in my review, I determined that Kamek, as outside counsel, could provide legal services to the agency to investigate or to review the complaint referred by Travis County.
And what would be your position as to whether he had the authority if he stepped outside the scope that you had drafted so carefully in the addendum A?
Objection, Mr. President. That would call for speculation.
Sustained.
Was he authorized to do more on behalf of the Attorney General's office than you set out in the scope A of the contract?
Not in the draft that I wrote.
All right. Now, when you sent these two contracts, or these proposed contracts, that you've just raised an issue right there. Were these drafts or were they final contracts?
They were both drafts.
So at the time you sent these out to Mr. Kamek and to the Attorney General, what was necessary to make them a binding contract where the Attorney General's office had actually legally hired Mr. Kamek? What process was required?
Objection, Mr. President. This actually calls for a very important legal conclusion. And this witness is not qualified to reach that conclusion on the ultimate issue.
I'm asking him what process within his organization was necessary for it then to be, at least him to consider it, a complete contract with the agency. Let me put it that way.
That is a different question than the one you asked.
So I'm going to sustain the first objection. I'll sustain.
But he's allowing the second one, is that right?
Well, you can start the second one now.
One
more time.
Thank you. So what was necessary in your mind as the person responsible for both drafting and initiating these contracts to make the drafts you sent to Mr. Kamek and to the Attorney General? What was necessary as far as your procedures and your experience and in your opinion to make it a contract that where Mr. Kamek was actually officially hired and entitled to be paid under the contract?
Objection, Mr. President. That question is extremely compound. There are several questions in it. Procedures, policies, his opinion may be very different things.
Sustain.
The contract that you sent, had it been signed by anybody?
No, sir.
To be a binding contract as far as you were concerned and the agency and your responsibilities, whom did it have to be signed by to be a binding contract?
Under the agency's signature delegation policies at the time, it would have been Jeff Mateer.
All right. And if the contract at that time was signed solely by Mr. Kamek, do you have a contract, or does it have to be signed by somebody that can bind the agency along with Mr. Kamek?
It would have needed to be signed by the agency as well as funding obligated to pay for the services.
So did we ever get to that process that you were aware of at this time?
It was started. I believe June 4th, we started the internal approval process.
And that's the internal process. It's circulating it to the people on Exhibit 166?
Yes, sir.
Just to correct the record, the witness said June 4th. I believe you mean September 4th. Is that correct?
That's right. September 4th.
I'm sorry?
Let the record reflect September 4th.
Okay. The cover sheet would be 166, would it not? The contract, I believe, were the 164. 161, I'm sorry. I just want to make sure we got it straight.
Oh, I'm sorry. Were you talking to me?
We've got 160.
Be best to speak to the court.
166 is what I introduced it. You accepted. And that's a copy of the approval sheet. And that's what I was asking. I'm sorry, that's what I was asking about.
Don't talk over each other. Yes, sir.
166 is on the screen and it has been admitted.
Pardon me?
You can continue, Mr. Hardin.
I'm sorry, I'm all confused.
166 has been admitted.
Right.
166, correct?
And I thought you were changing the number on me.
I'm sorry, I'm confused by your statement. Maybe this would be a good time for a break.
All right.
In about 15 more minutes. About 15 more minutes, we'll have a break.
All right, thank you. So let's try to move through this real quickly. Did this start going through different procedures, and what was the outcome of this contract? Did it ultimately go all the way, or did it stop somewhere along the way?
It stopped
the approval process. And where did it stop?
Mark Pendley declined to sign the approval memorandum.
And when did you become aware that Mr. Pendley would not sign it?
I don't recall the exact date. I recall there were conversations that when I signed it, it would go to Mark Pendley next. I advised Jeff Mateer that was going to be the next line in the sequence. I also advised Mark Pendley that he was going to be next after I signed it. I don't recall exactly when Mark Penley declined to sign.
I think there are other documents that we can introduce later that would show that. We'll do it through other people. As to your involvement, Mr. Vassar, how would you view your role once you started sending out the drafts? Did you start having contact personally with Mr. Kamek, where he would have several different requests that you would communicate with him, or what?
I was the point of contact for Mr. Kamek just based on the introduction through General Paxton. After the internal approval process had started, I received a call from Mr. Kamek. I believe it was around the 13th of September.
What did he want?
He asked if there were any official documents or an official email address that we could give him.
And at some stage along the line, were there inquiries about whether he was going to have inquiries by him as to where he was going to have credentials?
I'm sorry, could you say that?
Was he going to have credentials? Did that ever become an issue that would show that he was authorized to work on behalf of the AG's office?
No, sir.
Did you ever provide him any?
No, sir.
Did he ask you for any?
He did on that phone call.
And what did you tell him?
I told him that he didn't have a contract yet. I didn't understand why he needed credentials to identify himself as representing the agency.
All right. Were you aware, what was your level of awareness as to whether Mr. Kamek, or belief, was authorized to be speaking for the AG's office before this process was completed? What was your belief?
He had none. He had no authority to represent the office. And
in your opinion, when would he have had authority to represent the office?
When?
Yes.
When he had a binding and executed contract.
And did he ever, to your knowledge, have a binding and executed contract?
Objection, Mr. President, this once again calls for a very important legal conclusion that goes to the heart of the matter.
I'm not asking him for a legal conclusion.
Witness can answer the question if you know of your own personal knowledge, not on hearsay.
On October 2nd, I believe Brandon Kamek sent a contract that appeared to be signed by General Paxton and Mr. Kamek himself.
Do you know when you first saw that?
I believe it was October 2nd.
Is that the first? Describe for us, were you aware before, any time before that, that General Paxton had decided to sign the contract on behalf of the Attorney General's office?
No, sir.
Did you have any idea at that time when you saw it on October the 2nd, how and when that happened?
No, sir.
Did Mr. Paxton ever tell you that he had signed a contract personally with Mr. Kamek?
Yes, he did.
When did he tell you that?
I believe it was Friday in October, which may have been the 3rd. He emailed me and informed me that he had signed the contract with Kamek and that there had been a mistake in Jeff Mateer's letter terminating the contract as an invalid agreement.
We need to jump ahead a little bit for this particular portion. You're aware, or you're not, that, well, let me ask you, do you recall what date you and a group of people went to the FBI to report your concerns?
September 30th.
All right. And are you aware then when y'all informed the Attorney General that you had done so?
October 1st is when we notified General Paxton.
And after you informed the Attorney General, did it sometime on either September the 30th or October 1, had Mr. Kamek been sent a cease and desist letter?
Yes.
And whom did he send a cease and desist by whom sent him a cease and desist letter?
I believe Mark Penley sent a letter to Mr. Kamek, and Jeff Mateer sent a separate letter to Mr. Kamek.
And then separately was action taken in the courts concerning the subpoenas, grand jury subpoenas, that Mr. Kamek had obtained and was serving. Was there separate action undertaken by either Mr. Penley or Mr. Mateer?
Mr. President, we object as to leading.
Are you aware of any?
Abstain.
Excuse me. Are you aware of any action that had taken personally aware of any action that was taken in the courts concerning the subpoenas that Mr. Kamek had been serving?
Mr. Penley moved to quash the subpoenas.
All right. And so then when you get a letter, did you get a letter from the Attorney General? And if so, what date that was, or text?
It was an email indicating to me that he had signed the contract with Brandon Kamek and that Jeff's letter telling Kamek to cease and desist was improperly sent.
All right. At that time, during that first week in October, when we got to October 3rd, what was your status with the agency?
I was still employed.
And had Mr. Mateer resigned the day before, October 2nd?
October 2nd. I believe he resigned on Friday.
All right. When he resigned, had he sent a letter to Mr. Kamek before that, if you know?
Yes.
And at that time, were all of these actions being done with the involvement of each of you deputies that had been called colloquially the whistleblowers?
Yes.
Now, before that, when this contract, what was your involvement as far as the contract for Mr. Kamek once Mr. Penley refused to sign off on it? What happened then?
From what I recall, Mr. Mateer and Mr. Penley sent a cease and desist. Mr. Kamek followed up to our agency mailbox, just the general mailbox, with invoices that he had purported to work under some authorization from General Paxton. Because we didn't have a record of a contract or a copy of a signed agreement, we informed Mr. Kamek that we could not pay him, and his response was that he had a signed
What date was that?
I believe it was October 1st.
All right. And during the time that you were going back and forth with Mr. Kamek about the contract, were you the person that was communicating with him?
He had emailed me directly, but the rest of the conversation was through the general mailbox that he is.
Did he send you an invoice seeking to be paid?
Yes.
Do you recall when he did that?
It was right around the same period, so it would have been October 1st.
And when he sent you an invoice to be asking to be paid, what was your response?
We informed him that we did not have a record of a contract under which to pay him.
And did you tell him you need a contract signed by somebody within the agency?
Well, we just told him we didn't have any contract with his name on it.
That had been signed by anybody?
Correct.
So what did he do?
He responded and said that he had a signed contract.
Do you recall what date he told you that he had a signed contract?
He provided it to us in the morning. I believe it was October 1st. Or no, I apologize. It was September 30th because we went and met with law enforcement on September 30th.
And did you get a contract from him that had been signed by the Attorney General before you went to law enforcement?
Yes.
Now, at the time this was all going on, were you willfully and totally involved in the actions that were decided and that led to you going to law enforcement?
Yes, sir.
Why did you go?
I formed a conclusion, just based on my good faith belief.
Keep it to the microphone.
That General Paxton was using the power and authority of his office to benefit a private individual.
And what was your opinion as to whether or not y'all had done everything you could to stop him before that?
Well, all of these sequences of events ranging from May of 2020 to the foreclosure letter in late July and August of 2020 and the Kamek issue in August and September of 2020, in isolation were just activities that we tried to handle for General Paxton.
Mr. President, I'm sorry, I must object as non-responsive to the question.
Well, let me continue with
Sustain.
you.
Re-ask the question.
Thank you. Now let me ask you this. What was your state of mind in terms of the degree that you, in your opinion, of the degree that you and others had engaged in to try to dissuade him from this conduct that you disagreed with?
We had repeatedly suggested that the positions that we were being asked to take were contrary to established law and policies. When we did that, he directed us to find a different way. So as lawyers do, we found alternatives, and those were the alternatives that he chose.
Well, then what was the tipping point about September the 29th or 30th that led you to decide to go en masse to the FBI?
Well, it became clear at that point that the degree and the extent to which General Paxton appeared to be using the office to benefit a single private individual, to target and harass law enforcement, rose to a level that, just based on our good faith belief, criminal activity had occurred. And under no circumstances did Brandon Kamek have any authority, either under a contract that was unsigned or a contract that was signed, or by some deputation by Travis County District Attorney's Office to serve as a special prosecutor for the Office of the Attorney General. So he was representing himself in a capacity that did not exist, and doing so for the benefit of a single individual.
Under those circumstances, did you feel that the Attorney General had any authority to appoint a, quote, special prosecutor?
No, sir.
Objection, Mr. President. The objection is relevance. I don't believe that there is any contention on the part of the House Board of Managers that General Paxton appointed a special prosecutor. That is not the allegation.
Sustained.
Are you aware as to whether or not Mr. Kamek was going around and serving grand juries subpoenas, claiming he was a special prosecutor of the Attorney General's office? Are you aware one way or the other as to whether he was doing that?
Objection, that would call for hearsay.
No, it doesn't call for hearsay. This witness can be cross-examined about what the basis of his knowledge is, and then he can say whether it's solely hearsay.
Overruled it.
Thank you.
You may answer the question.
Yes, sir. I'm aware.
And in fact, was Brandon Kamek ever hired by the Attorney General's office, by anyone in the Attorney General's office, and designated a special prosecutor?
No, sir.
And what is your opinion as to whether or not they even had the authority to hire a special prosecutor in this case under the facts that you knew him to be?
Objection, Mr. President. Lack of foundation, speculation, and relevance.
Sustained.
Mr. Vassar, what was your concern if y'all did not go to the law enforcement on September the 30th of 2020?
Well, the concern was that it would only get worse. General Paxton's use of the office would only continue to be more extreme, to benefit Nate Paul, and the potential for us to be labeled as co-conspirators.
How long did you remain with the Attorney General's office after October the 1st, 2020?
I was terminated November 17th, 2020.
And what was the stated reason for terminating you?
For disclosing confidential information outside the agency.
And did they describe to you or give you anything in writing to tell you what confidential information you were supposed to have disclosed?
No, sir.
Did you ask for a meeting to find out what it was?
I asked what it was, and they didn't provide a response.
Who replaced Mr. Mateer as the first assistant after Mr. Mateer resigned?
Brent Webster.
Is he still acting as the first assistant to your knowledge?
Yes.
Did you, without going into other conversations, did you seek to find out what confirmation or what information was being used to terminate you And did you ever find out what it was?
Yes, I asked Mr. Webster what information I had allegedly disclosed outside the agency, and he didn't give a response.
To this day, do you know what confidential information you were supposed to have revealed?
I have not received a direct answer, but based on the agency's own internal whistleblower report, they've made allegations.
Finally, when you were terminated, how old were your children by then?
6 months to 4 years.
I believe you indicated, but I'm not sure I remember. How long did it take you to find another job?
6 months.
How did you live?
Just on savings that we had saved.
And when you took another job, where is it now?
Yeah, it's for a local nonprofit policy think tank here in Austin.
At the end of the day, in light of all that, and by the way, have you sued? Are you a whistleblower that has sued the Attorney General in the state of Texas?
Yes, sir.
Why did you sue?
Mainly for my family.
What do you mean?
Well, to take care of them financially, but also just to be a good example for them.
And what do you mean about a good example for them?
Just to stand up for the truth.
You read this report that they put out back in 21?
Yes, sir.
You saw what it said about you?
Yes, sir.
You saw what it said about the others?
Yes, sir.
How would you rate the level of accuracy of the report that Mr. Webster says he primarily prepared?
On a scale of 1 to 10, I'd give it a 2.
And was that report been out on the internet to the world at large?
Yes, sir.
All about you and the others being rogue employees?
Yes.
Is this the first time you've ever had an opportunity to tell your side since this all happened?
Yes, sir.
You feel better or worse?
It's not fun.
I'll pass the witness.
We'll break now until 5:25, and members, there are some snacks back in the back for you to get a little energized, and we'll come back for about another 60 to 90 minutes, depending on how it goes.
Okay, that's a lot of interesting testimony we've heard from Ryan Vassar. Just this whole description of how this FBI brief came to be released.
Yeah.
What's your thoughts on that?
More following the narrative that the prosecution has been putting forward about how outside the norm this is. It is unprecedented, very, very strange to release, first of all, law enforcement data, as we've heard and we've talked about before, how that has always been the common practice of the Attorney General to not release current investigation information. But on top of that, this is information that was sealed by a federal judge. And I just, for the public out there, a judge's order is a big deal. A federal judge is the biggest of big deals. These are people that have a lifetime appointment. They're essentially emperors.
Right.
The only person bigger than a federal district judge is the Circuit Court of Appeals that is over them and the U.S. Supreme Court. And so the idea that some attorney general in one of the 50 states could just say, you know what, I don't care about that federal judge's order sealing this information. We're going to release it anyways to the target of the investigation is pretty shocking. It was pretty damning, pretty outside the norm, which again just kind of follows that general theme. of how unusual this is.
And I think it illustrates the audacity and arrogance of Ken Paxton, that he was quite willing to push through on this and to push his people to do it.
It's a pretty stunning display of, but again, I think what you see is over and over them showing just systematically how they went outside the norms of the office.
And how direct Paxton was involved. This isn't so-and-so told me that so-and-so said. This was Ken Paxton said, find another way.
Right.
This was Ken Paxton saying, I don't care what that is, I want you to do it this way.
I want this to happen, you find a way to make it happen.
Right.
To his staff.
Well, and Vassar said, you know, that when the Kamek situation arose, I feel like the Kamek situation is the straw that breaks the camel's back, right? This is the one where they go, okay, you know, first we had the open records thing, we had the foreclosure thing. We might not like it, but we can muddle through. But now we have subpoenas being issued, we have banks being served, we have requests, subpoenas for emails and phone records of law enforcement officers and magistrates and that kind of thing. So now we're in different territory.
And it brings up their own personal liability when it all breaks open.
We heard there, close to the end, how he talked about I didn't want to be a co-conspirator.
Well, he said the concern was that it would only get worse, and for us to be labeled co-conspirators.
And that's a big deal, especially if you're talking about something where the federal government is possibly prosecuting you. If the feds decide that you have committed a crime, the number one charge that you see in federal prosecutions is conspiracy.
Yeah.
And that is how those indictments get so big and so nasty. That was a very legitimate fear, especially considering that a federal prosecutor could very easily allege that by releasing information that had been sealed, that they had run afoul, and that if you were involved in that, then you ran afoul.
And I don't mean to minimize at all their concern for the public good. I think they are all very sincere about that. But I think self-preservation was kicking in too at this point.
Well, I also think that
there's some definite truth to that.
Yeah. I also think that there was, this was a continuation of a pattern, right? At first it's, that's strange, but they didn't have enough information. All the pieces hadn't kind of come together. But then after the foreclosure, there's this, there's that, they're adding on top of each other, then this happens. So it's a continuation of a pattern. They're starting to fit the pieces together, and then this one is so audacious, arguably violating a federal order, sealing records, giving away information from from the FBI. Again, we talked about it at the last break. The Attorney General is the top cop. He is the chief law enforcement officer in the state. And generally speaking, more than generally, every single time I can think of, law enforcement sides with law enforcement because they're all on the same team. They're all prosecuting crime,
they're all
investigating
supposed to
crime.
be on the same team.
And so for them to, so we heard Ryan Vassar talk about how we reached out to the FBI as per usual, and then it gets released without the FBI even having a say. Again, that very, very strange.
Very strange. And I can understand the alarm that must have run through this group of people as the word spread about what was happening.
Well, yeah, because again, you have Kamek going out, and they haven't played the audio yet, and I don't know, I'm assuming they will, but when Kamek goes out to deliver the subpoenas, at least in one case, to one of the banks, he has the attorney representing Nate Paul with him.
Yes.
Again,
the audacity is breathtaking.
I cannot emphasize enough how rare that is.
This is
not rare.
It's
unheard of.
Yeah,
it just doesn't happen.
Far more than rare.
I mean, when I listened to that audio when they released all those documents a couple weeks ago, I just my mouth dropped.
Yeah.
I mean, first of all, I was going. I'm not clear on who recorded this. Was it Kamek that recorded it? Was it the bank guy? I think it was probably Kamek because there's more than one of them. There's like a couple of audio recordings where they've gone to deliver subpoenas, and I'm just,
well, which makes it even more astonishing that he would record that happening.
Yeah.
That Kamek would report.
Yeah,
doesn't that seem even more astonishing?
I can tell you, I've never had a detective give me a call and say, "Hey, you represent so and so. Why don't you come down to the crime scene and we'll let you be involved?" Defendant's attorney. It's really shocking. On top of that, there's so much to unpack here. The more I think about it, it came out as a fairly dry presentation, and I think the defense did a good job, and we can talk about this more. The defense did a good job of interrupting the flow. The defense attorney was very successful with his objections, and I think he had Rusty Hardin stumbling a little. But there was more to unpack there. The fact that, generally speaking, it's very common to put an independent outside counsel.
Right.
That happens all the time. It's a huge office. There's all sorts of issues. Sometimes there's specialized issues, and they don't have that many lawyers. So yeah, that's fine. But when it comes to a criminal investigation, they're not. They never have the jurisdiction to prosecute in that instance. And the fact that he drafts the contract the way they always draft the contract, and yet again, this is going to be the theme for the prosecution. Again, Ken Paxton says, no, not in this instance. When it's benefiting my buddy, that's going to be the theme. I want you to go outside the norm and do something completely unprecedented, and give him wide-ranging authority. All of that put together, it really is shocking.
And you're right. The theme is for my buddy.
Right.
We're going to do this way, this really unusual, anomalous way to benefit my buddy.
And we haven't heard it yet, but of course, the affair and the mistress and the fact that she works for my buddy.
Well, we heard some of that from Mateer yesterday morning, which was, this whole description of how, the nexus is. It
puts it all together.
Because,
does. Right now, if you're just hearing this out of context, if you haven't been following this, it's easy to say, I don't understand why he would do all this for this guy. There has to be a rational explanation. But then once you find out that there is a very rational explanation, it's just not okay. The rational explanation is that he's doing this so that, because you're giving me the keys to my mistress's apartment or whatever. That's pretty incredible.
Right. Because they're going to ask me about this. They got me in the 6 o'clock, so I'm curious. What are the biggest surprises to you guys today?
Well, I don't know why this surprises me, but I do think the scale of the audacity and the arrogance is astonishing. The sheer scale of it, the unprecedented nature of it, and the whole defense that the AG, of course he can do this. Right. He's the Attorney General. No.
That doesn't mean you can do anything. Yeah, I agree. I hate to not offer an additional surprise, but I completely agree. It shouldn't be surprising because before Dan Patrick issued the gag order, I can't remember, I think it was Rusty Hardin, said when all the facts are out, it's going to be shocking how audacious, I forget his exact words, but he told us that the scale of the audacity, the scale of how irregular was going to be really shocking. All the facts weren't out, wait till you hear. Well, we're hearing. I have followed this. I was aware of the basic allegations. I've read the articles of impeachment, more than your average person. When Rusty Hardin said that, I thought, oh, okay, get your popcorn ready. This is going to be interesting. Even knowing all that coming in today, that it still has surprised me how irregular all of this is.
It is the systematic use. That's what the testimony has shown. Mm-hmm. Right. The systematic use of this office to further the interests of one man.
One person.
That's right.
Nate Paul.
That's right.
And over and over, the office, Paxton asking his people to do things that go outside the norm.
Exactly.
With the open records situation, the foreclosure situation, the Mitty Foundation, just over and over, and then you have this thing with Kamek, and this hiring and then going out and doing subpoenas. Just all the stuff is just wild.
I would love. I'm sure my clients would love to be able to have an attorney general to do this on their behalf. to investigate the investigators, to give them access to sealed documents. My clients would love it. I would have to tell them, yeah, that's not going to happen because, you're not
I think that
Ken Paxton's buddy. I just,
even John Grisham could not write a novel when
Stranger than fiction.
The publisher would go, no,
this can't happen.
Yeah.
No, this can't happen. Go try again.
And again, you can't say enough that Ken Paxton, until he was suspended, was the state's top law officer, and the AG's office is the law firm for the state of Texas.
Right.
That's right.
I mean, that's really important when you put this all in context.
Yeah.
This systematic stuff. And these guys, all of these guys, these are true believers.
Mm-hmm.
These are and every one of them, and he didn't say which nonprofit he went to work for, but it wouldn't shock me if it's something along the lines of what Mateer
Right.
It is.
and
He didn't
and
go
Banger
join the
are doing.
ACLU
No,
or something like that. He went
Right.
to join some kind of Federalist Society, super conservative. I don't know either, but it would shock me if it was anything.
And when you think that this is the law firm for the state of Texas, and then we're doing all this for this one Texan, and then you factor in that there were 75 times when this office declined to represent state officers, state agencies, universities,
Right.
declined to represent them.
Right.
The very
And
people that
they are
supposed
charged
to. Right.
with, and
Yeah.
those entities and individuals had to go out and use taxpayer money to hire other attorneys to do the work this office should be doing.
Right.
That's
I mean,
the-
it makes
yeah.
it even worse.
That really is a good reminder, because I've seen some of the comments saying, this really isn't against the taxpayer. That's a great example. The idea that the Attorney General's office is there to represent state actors, state universities, state agencies, and when they don't, because they're very busy carrying the water of some private citizen who's buddies with their boss, that is a direct impact to the taxpayer. That is a direct affront to the taxpayer.
I just want to note for the people that are watching on YouTube right now, this is not from today.
Yeah.
Ken Paxton is not in
Has
the
not
Senate
been there
chambers.
at
Yeah,
all
that's,
today.
This is video. This would have been video from Tuesday. 'Cause
Morning,
The only
yeah.
right Tuesday morning, because Ken Paxton has not been in the
They've
Senate
not required him to
chambers.
be.
He's not required to be.
Right.
And so he has not been there.
There's been a lot of discussion of that. So let me kind of address that. This is not a standard criminal trial. This is a political trial, and impeachment is a quasi-criminal, but it's essentially a political trial. In a criminal trial, the defendant has to be there. There are rules that require that. This is a very different place. No criminal trial gives the jury the right to vote on the rules of the trial and to change the rules in the middle of the trial. These are crazy things. This is the way
vote
this
on all
works.
the motions when
Right.
it's
The
missed.
jury doesn't vote on the motions. It really is strange. It's a upside down world. But in this world, he's not required to be there, and so they're making a strategic decision. I'm sure his lawyers, I would be concerned about the same thing, are concerned about, or would be concerned about, he's going to be watched every second, judged every second, every facial expression he makes is going to be judged, and it's just easier not to have him there. On the other hand, there certainly is oh boy, why isn't he there? What's he doing?
Well, and my
it plays both
understanding is
ways.
he's already been doing fundraising on this. That this trial is persecuting him.
Right. I wouldn't. Yeah. I hadn't heard that, but that doesn't sound at all surprising.
No,
Given
and
the political
actually,
nature of this.
when Bud Kennedy was here yesterday, he showed us the email that went out. And I think that's why the prosecution has taken pains to walk each of these witnesses through to say, okay, tell us your conservative bona fides. Where'd you go to law school? Where'd you grow up? Who do you work for now? And that kind of thing. And so they've really made sure they're walking folks through to show these are not your rhinos. This is not the ACLU type.
Not some hippie.
This is not a hippy dippy lawyer. This
malcontent bad employee who gets
No,
kicked
these
out
are
of everywhere he goes.
true believers. Yeah.
They believed
evangelical
in the mission,
Christians. They believed in the mission of Ken Paxton's Attorney General's office. They wanted to serve those goals and that vision, and this is how it ended up.
And I think they would say that besides Nate Paul, they still do believe in that mission.
Yes.
Oh yeah.
Absolutely.
Which is
I think
why
so.
I want to return to that. Is I'm sure what they're saying is
Yeah.
I want to return to when we did that.
Yeah, right. Which is why Vassar, Banger, acknowledged that they had taken some cases to the AG's office. That was the thing that
Yes.
Oso didn't
I still
follow
believe
up
in
on.
the system, basically.
Right.
Is
Yes.
what he could have said
I
in
believe
response.
in what Ken Paxton, says he stands for over here.
When it
I'm just
doesn't
not for this.
involve Nate Paul,
Right.
Like I have faith in the system as long as Nate Paul's not involved. Is essentially the response. For a second, I just again being the lawyer, kind of law nerd out here for a second. I do think the defense has done a much better job in this kind of middle to second half of the afternoon, affecting the pace. This lawyer that's going now has been a lot more effective than Mr. Oso. I think. Obviously very different styles. He's a lot more understated, but his objections have been very effective. I'm sure the commenters on YouTube have noticed that, their rate of getting their objections sustained has skyrocketed.
Right.
He's being very effective. And, frankly, and I don't blame him for this, I think he's taking advantage of the fact that Dan Patrick is not a judge. He's layering his objections.
Very effectively.
He's layering his objections. He's saying, this is relevance and hearsay and outside the scope and this and that, and basically making it such that Dan Patrick, I'm guessing, is thinking, well, it's got to be one of those, So he's getting those sustained. A couple of times, just on a pure legal basis, I sat here and listened and thought, those are nonsense objections. I know the rules of evidence; none of those apply. But Dan Patrick is giving him that because one, he's not rolling his eyes and acting like Oso was.
He's being very
respectful. Yep.
Right.
He's got a good courtroom demeanor, and then he's very meticulous, and he's not getting scolded like a bad child for talking over and all that. And he has effectively turned the tables on Rusty Hardin to some degree, because a couple of times Rusty Hardin talked over him, and then he started getting scolded.
Right.
And we talked earlier about Rusty Hardin kind of giving a master class. Well, here's what a seasoned lawyer can do. Rusty Hardin is not impervious. He can't, he can be bested. And I think for a short period of time that this lawyer has done a really good job.
Yeah, I'm not clear on who that lawyer is.
I keep calling him this lawyer because I don't know his name.
He's been identified. I went through and looked to see. I can't find who he is.
Well, I give him kudos. One defense lawyer to another. I think he's doing a very good job.
Of breaking up the flow.
And look, breaking up the flow. I seen comments on YouTube, and you folks are just like real, just like jurors. Now, obviously not these jurors because you're not state senators, but I mean that's the idea. If you can break up the flow and make it boring and make it monotonous, make it dry, then the effectiveness of that evidence goes way, way down. And
lose the flow of the narrative.
Right, and this was very powerful evidence, but I don't think it landed as well as it could because the flow got affected. And a few times, I feel like Rusty Hardin could have easily pivoted and got his point, but the objection threw him off. And then he kind of like we talked about earlier, why did Oso turn away right before he made his point? Rusty did it a few times.
Right.
Where it would have been easy just to reframe your question and get it in. The witness has already heard what you want him to say,
Right.
And so just ask it another way, and the witness is going to give you exactly what you said. But then Rusty kind of got flustered and moved away. So I think the defense is doing a really good job there.
But I still think overall he's gotten some decent stuff out of Vassar.
No, yeah.
Oh, yeah.
It's not been a bad witness. Vassar, I still think, has
Banger
been a very
was
Banger was fantastic, and other than that one little he wouldn't say yes stretch, I think he never got flustered. He never got upset. He did a very good job. This witness, although he never got upset and he's been very calm, he wasn't as interesting. And even though the facts of what he was laying out were very powerful, the presentation wasn't nearly as powerful.
What do you think about the whole contract thing and who signed it and that kind of thing?
The details that are kind of you get mired in.
Right.
I don't think any of that is really all that important, but it's a great job by the defense to throw that up and
Well,
let
and I
you get
think
caught in it.
the fact that the end of it was that Ken Paxton himself signed.
Right. Right.
Even though, I mean, that it didn't go through the procedures. That
And he had, and he did have the authority to do that.
Right.
Yes,
I mean,
that's
and
true.
I think we have to.
Yeah.
He had the authority to do that.
But
I
it
think
wasn't the norm.
It was not the norm.
Yeah.
And the issue is,
he bucked his entire staff to
right,
do
he
it.
bucked his entire staff, and then then you get into the questions, and that's where they feel like the staff felt like, which is what led them to go to the FBI, was they felt like the reason he did that had an illegal,
Right.
or abuse of office kind of thing.
Right. Right. Yeah, because I mean, some of the commenters have pointed it out, and it's a fair thing. The boss has a certain amount of leeway. He's the boss, right? And he can say, underlings, you're underlings, and I don't care what you say. Sure, I run my law office. I'm the boss. But a whistleblower has every right to call law enforcement if the boss is essentially violating the law.
And in this case, attorneys have a responsibility.
That's right.
To do that.
Especially the top law enforcement officer in
Right.
the state who represents the state. He has the highest of kind of duties to us as citizens, and yeah.
A lot was made of the fact that they went to the FBI without telling Ken Paxton.
I think that is a great red herring argument to throw out,